Hey, what's up, guys? Welcome to Sign Language Splaining the Internet. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, becoming more significant by the day, I suppose, because it appears that I am now cited in yet another court document. This is not the first court document that has blessed my YouTube channel with some poor sap of a judge's clerk who has to watch some of my show for work. That's the real sadness. It's not that they have to watch my show, because I hope to put on a show that brings joy into the hearts of every viewer. But I know that for many people out there, more by the day, it appears, it's actually work. It's actually work, and they have to sit and watch it. And there's just something less magical about having to watch things, right? About being forced against your will, or on pain of payment to watch it. Like, if you paid me to watch, I don't know, what do I even like? Generic movie as a job. If you paid me to do that, I would enjoy the movie less than if I just wanted to watch it, right? So I wish my channel were growing organically rather than through the sick, twisted machinations of Monica Rial, Ron Toye, Jamie Markey, Funimation, and Counsel-in-Chief Casey Eric Esquire. With that said, I have to do a special shout out. Because there are so many of you guys. Are viewers who have been watching for a long time, or you're very, very consistent, or some mix of those two. And I love and appreciate you guys. You guys are here all the time. But I've noticed a lot of other viewers lately. So I would love to thank a couple new groups of viewers out there. To the staff of Casey S. Eric, thank you. Thank you for coming to the show. Thank you for watching. I will make it long for you, okay? Which normally is something she said, but today it's something I said. I will make it long for you, just for you. Because I know those billables are annoying. I know filling those quotas is annoying when you're in that corporate law setting and you have to answer to partners because you're not like one of the senior partners, so you have to make sure that your billing is in and on time and correct and all that stuff. Like if you were one of the senior partners, it might not matter as much, but since you're not, and you're not running your own firms, you have to answer to someone else. So thank you for watching. I promise to go ahead and make this one count. Several of the other ones, don't be a stranger. Don't be a stranger. As long as you're getting paid, I'll make these go on just a little bit extra. At least I'll get you that 10th, right? At least you can always count on me for that one more 10th of an hour. And I will do that for you. Next, I have to welcome Tora-san, the fattest and most ridiculous cosplayer on the planet. Tora, baby girl. Well, when I say baby, don't mistake me for saying small, okay? Just let's get that out there. Tora, hi. I'm so glad you're still watching. I'm so glad you're still using an archived screenshot of a Google review that was taken down because it was fraudulent, and trying to use that to say that one of my clients ended up in jail. I'm really glad that that's the one you picked, the one that got actually deleted by Google for being false. There are a couple others on there that are false. All of the 1 stars, never heard of them. Actually, a lot of the 5 stars, those are false too. I didn't put them up there, but they're there. Google doesn't really remove reviews very well, but it's funny that you picked the one that they did, where the guy said, I'm in jail, don't help him. None of my clients are in jail. Not one. Unless something new happened. None of them are in jail because of me. Let me clarify that. There's certainly the possibility that one or two of them would end up in jail later. You tend to run into repeat offenders from time to time. But this is all exposition, Tora. Thank you for watching. I know Uber Eats, you got them on speed dial and they can't stop making deliveries to your house. So I appreciate that in all the time sitting on the couch, wishing you were cosplaying, but instead actually just ordering from Uber Eats. You know, I'm glad that you spend it watching me. It means a lot. It means a lot. To Shane Holmberg, the man, the myth, the legend, Shane, who can't turn away. He will block you. Well, me. He'll block me and many of you as well, I'm sure. And he will sit, but still, like, unblock to post something and then re-block. I think that's how he does it, because apparently he posts on my threads all the time. I have no idea. Maybe he doesn't do that. But man, does he monitor it. And that's funny because I see him popping up in mentions all over the place. And I figured he'd be popping up in Payless, but then I remembered the all-you-can-eat Payless option is gone. It went the way of the Mohicans, right? It is thrown right off a cliff, and then dying of old age. That's the last of the Mohicans. Now the Mohicans are white. Daniel Day-Lewis. That's all that's left. So Shane, I guess he doesn't have anywhere to go anymore. So Shane, thank you for watching the show. I love that you keep lying, overtly, provably lying, like saying everyone was there today at Vic, except for Vic, at the deposition. Well, that's interesting because all you had to do was like actually just find out if they drove to Tyler to go to Ty's office where the deposition was scheduled and see if they went to Ty's office, which they didn't. So that's a weird lie. It's a strange flex. I don't know why you feel the need to do this, but Shane, someone out there cares for you. Someone out there cared for you enough to sacrifice their daughter to you, the most disgusting cretin on the planet. I don't know what person, like, guys, think about this. Think about this. The deal between Shane and his wife's dad. Think about this. I'm getting biblical here, y'all. You know the reference. You know the reference. The deal between Shane and Shane's wife's dad is the same thing that got Sodom and Gomorrah burned to the ground by God. That's how horrifying that situation is, right? If you know the story, if you bust out your Genesis, all the people in town are coming and they're trying to go after the angels, right? And they're going after the angels. And Lot's like, nah, don't worry about them. Take my daughters. You can just have your way with them and your weird little orgy that you're planning, and that's fine. Just leave these angels alone. Fire and brimstone, and they're all dead. Oh my God. Whew. Shane. You didn't dodge a bullet. You dodged a meteor shower. I think we should all be taking notes. Oh God. But anyway, thanks for watching. Please watch out for falling sky. You weird, disgusting thing. What's next? I'm trying to think. Guy, I've been gone 2 days. I feel like I've been gone a month. There's all these things that happened. Funimation's lawyer has filed their response, and well, not the response. Whoa. Has filed the Rule 11 agreement that basically sets out their response deadline. And we'll cover that later in the stream. the meat of this stream, we're going to jump right into some documents as soon as we get the initial super chats. There's a lot of them today, so I'm going to go through them as fast as possible. And we're gonna jump into the document, and then once we hit that document, the flow will pick up, and we'll be trucking through. We're gonna go through all of the filing of Casey Eric. I'm gonna try and hit you guys with a little bit of stuff here. There's one thing I don't have. I don't have the actual whatchamacallit case for the. He cited an order. He cited an order in the case, and he did it like really poorly. Let's see. Where is it? I mean, this guy's citations are all terrible. Let's see. Where is... I'm trying to find this. Where is this? Guys, this filing is so bad. This filing is so bad. Give me just a second. He cites this order that says the rule of habeas dibsies, right? That's what he's going for, but it's a terrible order that he cites because it says like the opposite of what he wants. I want to see if I can get that order. Let's see. Just so you guys know, anybody who says, oh, it's in the document. Okay, never mind. We'll get there. Anybody who says it's well settled law without any citations to it, okay. All right, let's hit these early chats and we'll get into these documents. We'll get into the documents. All right. James Card. Very sorry I haven't kept up with these. Hey, no apologies needed, my friend. Just finished with moving to a new town. If I recall hearing right, the big day is tomorrow. Yeah, there's a hearing tomorrow. I will do my best to get information out of that hearing. The judge might not rule on the hearing or on the motions at the hearing tomorrow. They may take it under advisement. Don't know. Won't know. Can't know until tomorrow. I'll try and get the information. I'll try and find out what happened and see what we can do on that. Hope you've been safe and keep schooling these social justice mobsters. You're the best. Hey, thanks, buddy. Back at you. Always safe. Always safe. Disrhythmia says $20 dues just for you, Mr. Rackets. Do with it what you will. Can we ask Australians to respectfully ask Supernova to bring Vic back to Australia? He has a long history with them and lots of fans would love to see him back. Absolutely. Go ask him. That would be great. I don't know when it is. I don't know if it conflicts with his schedule and whatnot. Oh, and yes, while I have your attention, the mall appearance at the Jacksonville Mall has been relocated. To Martial Arts and More. Which is a dojo which has hosted several signings before, including signings by cast members of the Power Rangers and stuff like that. So, they're equipped to deal with a large crowd of people. They're equipped to have, a person sit down and do signings. Like that's what they've done there before. So if you're in the Jacksonville area, Jacksonville, North Carolina, right? That's the one. You can go see Vic. You can go see Vic there at the Martial Arts and More. The details are on my Twitter. Otherwise, they're out there. It was not. The mall canceled the appearance. We're going to talk about that later. I'm not talking about that until after the signing at Martial Arts and More. And then I will talk a little bit more as I get more info, right? Because there's some fuzzy details out there, and I want to get you guys accurate information, very accurate information. Like, really accurate information. We're trying to get the most accurate information possible on this one. And those of you out there who may be watching, I hope you're not concerned about how accurate that information gets. So, just so, I don't know. We'll see. Like I said, the goal will be the most accurate information about that cancellation. The mall has updated their event to say that it was not canceled, but it was moved. That was one nice thing the mall did. One nice thing they did. So, but after it's let's see, after it's all settled, I will get you guys as much information as possible. Okay, so next Ink Penification says, by the way, I don't know if you know this, but Anime Matsuri will also have another attorney, more specifically an IP attorney from Georgia. Also, you should change your channel to Law Journalist. Law Journalist. I did not know that. I did not know that, but that's pretty interesting. I'll have to find him and talk to him. Blaine20 says, long and shootful. Gray, son of Krieg, says, so I tried watching Tanya the Evil on dub, but Tanya's dub was that crappy, cutesy dub voice they do for little girls. I looked up who did this horrible voice and slammed my hand against my face. Of course, it's Monica Rial. Well, you knew it. You knew it. Dustin Fitzfar says, I don't know about y'all, but I'm paying to watch this boomer and I'm still enjoying it. Patrick Thompson says, Shane, I only eat Air Jordans on special occasions. Holmberg used to make somewhat legible tweets, but I think the soles of all the shoes he's eaten has caught up with him now. Love you, Nick Buddy. Roast him good. Let's dig in. Let's dig in indeed. Aubrey Lovett says, hey, Nick, big fan. I'll be at Matsuri, and I'd like to give Vic some words of thanks and encouragement. Thing is, I'm going as Jesus from Saint Young Men, the OG manga, the Bible. Do you think he'd take offense? Thanks. I think it depends on what you do as Jesus. But I have no idea. Phil Rogie says, hey, bud, I sent you a DM a while ago about Ye Old Big Man in the Sky. I get that it was off topic and I might have jammed it into a show that wasn't about him, but I was hoping for a response sometime. Cheers. I'll have to try and find it, my friend. Don't hesitate to resend me that. I might just have lost it. Perception Check says, Vic's GoFundMe broke $170,000. That is awesome, guys. Again, thank you so much. Consider again, if you can donate to that GoFundMe, again, please do so. If you cannot or do not wish to, that is also fine. Consider sharing it, please. Sharing it really, really, really has a huge effect. We've had it shared over 8,000 times. That's amazing. Let's keep that going. Anybody who can share it to your Facebook, to your Twitter feed, just share it every now and then because you pick up new followers. I need to remember to do that. I forget because it's pinned on mine, but I'll have to throw out another tweet for it. And I'll try and get an update on there as soon as I can get some interesting stuff. Probably after the weekend, I think we might get some more news on what's going on. All right. Big Ben Howard says, found your channel while researching law in prep for a bad faith lawsuit I'll be filing against a giant claims company. Surprised to see you covering my boy Zach's story. We were in Afghanistan in 08. Keep it up, my man. Oh, hey, awesome, buddy. Hats off to you, sir. And I will do so. I will do so. Stooge Muffin Stuffin. I never thought it'd be possible to top Pro Jared, but Monkey Jones did. Cheated on his girlfriend with a furry child predator. The worst part about it is that he knew about it. See Mr. Meatman's video for more info. Rip Monkey Jones. Mithrin Emmer says, of course Shane dodged the meteor shower. He has 100% invincibility to showers of any type. Just look at his chair for evidence. Oh, gross. Wands Gruberman says, Nick, my boy, just picked up a copy of Horus Rising. Cheers for all the streams. Fark, man, I first watched you when Worski did that interview about Donga, and now you pulling double the numbers on your own. LL Rekieta. Hey, thanks, buddy. Thanks. Swarm069 says, got paid today, so here's some love. Thank you. Gonna hit Vic's GoFundMe for the 4th time. Don't worry, I'm not going to break bank anytime soon. Just like Marky, justice will be served eventually. Awesome, buddy. Thank you so much. Vash Lancet says, I stand with Vic. Could we please get him to go to Arkansas Comic Con in September? Power Rangers and Voice of Batman is going too. So is Kevin Sorbo. Ooh, that means there's a chance. Love your streams as always. Also, have you tried Grimbergen? It's a new beer. I have not. I'm not a big beer drinker. So I'm not opposed to trying it. It just doesn't normally go on my radar. And Johnny says, hey, Nick, I'll be in Jacksonville this weekend interviewing Vic and doing event coverage. When we post online, I was hoping to get guys like you, Tug, Hey, etc. to help us promote the video for fans who couldn't make the event. Yeah, email me. Email me with the info. That'll be the easiest way for me to see it. All right, a couple more and then we're good. Alex Blade says, does Shane think he is running an effective disinformation campaign for Ronica? I don't know what Shane thinks. I don't know if Shane thinks. And is there any indication that Shane is in contact with them? Yes, there's some indication in that the tweets here, or the text messages he released from KamehaCon were actually from Ron Toye to KamehaCon. They were the other side of the conversation that I had. So he seems to have some contact with Ron Toye. I don't want to speculate on what kind of contact because that's gross. Let's see. Iron Hyman says, what the hell is in store for us tonight? Additionally, my mother's last name is Best and my father's name is Cox. When they got married, there were signs titled Best Cox Wedding. Reality really is stranger than fiction. That's fantastic. Dave A says, hey, Nick, 2 questions. Have you done the live stream about the Duck Dynasty BS? Nope, that's coming up soon. And have you heard from someone local to you about summertime nanny services, or should I email you? Yes, I have. I was kind of curious how they got my information. Now I have more information about that. I have not responded yet. I've been very, very busy. Hated7DTD says, thanks for being awesome. Greetings from Germany. Greetings back to you in Alemania. Wait, that's French. Oh, I don't want to do that. Greetings back to you in Germany. All right, guys. Let's do this. Here you go. You might see where this is going right away. Oh boy. What could this mean? What could this mean? The local rules of court for Tarrant County, Texas. Okay, here we go. Here we go. Here's the document. Here's the document. Let's get going, especially since we have 6,668 viewers. Just saw a quick 666 and realized that we're not dodging the brimstone. I'm sorry. Yeah, it was it's Germany in French. That was the joke. Okay. So here we have the motion to quash. Wait, the response to the motion to quash and for entry of confidentiality and protective orders, and a motion to compel. All right. Strap in, guys. This one's going to be a little bit dicey, long. We'll try and get through this stuff. When we get to the cases, I might actually shoot down the document to pull up the case so we can read those so we can read their citations, right? Because if he's gonna put them in the file, we want to check them out. Now come defendants Monica Rial for the first time and Ronald Toye for the 1000th time. Defendants herein and file this response to a motion to quash an entry of confidentiality and protective orders and motion to compel, and would show the following. What will they show? We'll see. We'll see. As shown below. See, you don't want to lie from the get-go. You don't want to lie from the get-go. Just kidding. Just kidding. We'll see if they show it. Defendant's counsel contacted plaintiff's counsel to arrange a mutually convenient time and place for the deposition. That's sort of true. The first thing they did was actually just serve notice of deposition and then contacted counsel to arrange the time and place for deposition. They served notice first, I believe. Defendants served a notice of deposition and a request for documents more than 30 days before the deposition to provide the requisite notice for a deposition that requests a party to produce documents. The requisite notice, let's just go to the local rules, shall we? Because these are going to matter. Let's see, where are we? We want to go straight down to Rule 3.11, Deposition Guidelines. All right. Requisite notice. They gave 30 days notice under, what did they say? What do they say here? Oh, for a deposition that requests a party to produce documents. Okay, so yes, a subpoena ducis tecum, and yes, I know it's pronounced wrong, and I don't care. I don't care. I love it. Subpoena ducis tecum. You gotta remember that these are Texans. Subpoena ducis tecum requires 30 days notice for the document production. So never mind the rules yet. We'll get to them in a little bit. At first, plaintiff's counsel agreed to the time and place of deposition. Sort of agreed to the time and place of deposition. Sending an email that says, this might work out, maybe, all of that stuff is not binding in any way, okay? These people are trying to make a whole lot of nonsense about some preliminary emails. These people haven't even filed their answers at the time. Mr. Eric has barely appeared before the court, just filed his notice of deposition. That's the closest he's come to appearing before the court in the matter. No answer filed. No idea if they're even going to file an answer. No idea. No acknowledgement of service or anything like that. They just go straight to the notice of deposition and then think that an email exchange is somehow binding. It's not. It's not. You've heard Ty talk about Rule 11 agreements. You've heard me talk about it. The Rule 11 agreement basically just allows you to enter into a binding agreement. These are a Rule 11 agreement, or this is a Rule 11 agreement between the two parties. Now we're bound. I guess I could look up. Let me get Rule 11. Remembering, I apologize, Texas is not my native jurisdiction for this stuff. So it takes me just a little bit. Oh my goodness. I have to check some of this stuff on the fly. Rule 11, agreements to be in writing. Go. Unless otherwise provided in these rules, no agreement between attorneys or parties touching any suit pending will be enforced unless it be in writing, signed, and filed with the papers as part of the record, or unless it be made in open court and entered of record. All right, so these, for all the whining that Casey Eric is doing about the fact that Ty emailed and agreed to the deposition, it's not enforceable unless it's, let's read the rule again. It's long and complicated. Unless otherwise provided in these rules, no agreement between attorneys or parties touching any suit pending will be enforced unless it be in writing, signed, and filed with the papers as part of the record, or unless it be made in open court and entered of record. So all this email crap doesn't matter. I know they want it to, but it doesn't. And Casey has to know this. You'd think he's a super lawyer, that Casey would know that all of this is a waste of time and money because they don't have a binding enforceable agreement until it's reduced to writing, signed by the parties, and filed. The emails are not. Stream of Cthulhu says, Nick, what if Casey is right? What if Vic has groomed you and you are continuing the cycle by grooming us in turn? Get groomed. Get groomed. But I would never try to out-groom the groomer in chief. That would be Jim. Sweetie Squad, rise up. You know, I'm a humble groomer. I'm a humble groomer. Jim is the master groomer, and we can't. Yeah, I don't want to step on any toes there. All right. Namrakisto says you should see the Rising of the Shield Hero. I really love the most recent episode and really love putting, in this case, into the various roles in yesterday's episode, particularly Ty, Vic, and Ronica. There you go. All right. Next. Plaintiff's counsel inexplicably changed his mind, which, by the way, is allowed. Is absolutely allowed. You can change your mind. It's not in writing. It's not an enforceable agreement. And started making various demands and adding conditions which he insisted on an agreement. Weird. In all of this, Ty is trying to follow the effing rule. The rule of civil procedure. Let's put a Rule 11 agreement in place. How about that? But Casey wants it to go against the rule. It's stunning. It's stunning. Austin Heartless says, buy yourself a decent fifth of whiskey with this super chat. I'll be getting my paycheck in the next 4.5 hours. Hey, buddy, congrats. Payday is a great day. Payday is a great day. And I will buy a nice fifth of whiskey. Okay. Insisted on an agreement or he would cancel the deposition. Well, there you go. Many of these conditions were requests for defendants to waive legal rights and remedies that are critical for their defense. What legal right and remedy is critical for your defense? And you're going to, like, I could make fun of this, and I will. And I will. This is one of the dumbest things in the document because this premises the rest of Casey's arguments as follows. Vic is trying to avoid deposition entirely. That is the premise of this response to the motion. They're trying to label this as Vic avoiding deposition entirely rather than what has been stated over and over and over. Deposition for all parties prior to the TCPA or yeah, that's it. Deposition of all parties prior to the TCPA. There is so much evidence that Vic is willing to be deposed just pursuant to an agreement for, I think, confidentiality and that the TCPA not be filed, even if it means extending the TCPA deadline an appropriate time until both Ron and Monica have been deposed. Nowhere ever does Ty or Vic's counsel team or whatever suggest that Vic should not be deposed. That's not in there. It's not in there at all. But that is the premise of this entire response to the motion. It's like if you went up to bat in baseball. Okay? And the pitcher told you exactly what he was going to throw. He's like, look, I'm going to pitch it right down the plate. And you're like, okay, I'm going to hit it out of the park then. And then you show up with like a bubble wand, right? And you're like, and the ball goes right through it because you're swinging at something else with a different purpose. It's weird. It's a weird thing. That was a weird analogy too. I'm sorry. But I don't know how to explain it because this is a super lawyer, guys. This is the top 1% of litigators because he paid $1,200 something to get his name listed on this $1 million judgment thing or settlement or whatever it is. The $1 Million Litigators Club. He paid $1,200 for an ad, y'all. He's one of the best lawyers on the entire planet with the best firm ever conceived, and yet he premises his entire argument on something that isn't true. It's going to haunt him this entire document. Eventually, Plaintiff did cancel the deposition using made-up excuses. So there was a deposition today. Where's Vic today? Where's Vic today? Oh, that's right. Vic's in North Carolina. So I'm not so sure it's a made-up excuse. Vic has an appearance to go to in North Carolina. He's there already. He's not available for deposition. Worse, plaintiff files an unsupported, haphazard motion to avoid the deposition and running up thousands of dollars of attorney's fees and expenses. Nope, not to avoid the deposition. Not at all. That's not in the motion anywhere. Nowhere is that is the idea that Vic would avoid the deposition. The following timeline depicts why plaintiff's actions here are obstructive and wasteful. Defendant's efforts for discovery and to request a deposition. All right, I'm eating crackers. Bad form. On Thursday, April 25th, in accordance with Texas Rules of Civil Procedure 21A and 21A, 21 sub A and 21A, and Local Rule 3.11, defendant served plaintiff with a notice of deposition and request for documents for Mr. Mignana's deposition to occur on May 30th in plaintiff counsel's office in Tyler, Texas. Pay attention to that. Let me just rephrase that, or restate that. Defendant served plaintiff with a notice of deposition and a request for documents for Mr. Mignana's deposition to occur on May 30th in plaintiff's counsel's office in Tyler, Texas. Okay. Defendants offered to work with plaintiff's schedule in order to conduct the deposition at a time that was convenient for plaintiff. See Exhibit A and B, April 25, 2019 cover letter and notice of deposition request for production. All right, let's see Exhibit A and B. I should open another copy of this. Can I open another one? Well, not right now. Okay, here's the cover letter by e-service. Mr. Beard enclosed his defendant's notice of deposition subpoena Deuces Tucum for the deposition of Victor Mignana to occur on May 30th, 2019, 10 a.m. in your office. I'm sure you appreciate the urgent need for this deposition in light of the pressing deadlines we are faced with possible motion to dismiss. I look forward to working with you to get this scheduled. You noticed him. You noticed him right here. Notice of intention to take oral deposition. Please take notice that defendants intend to take the oral deposition of plaintiff blah blah before a certified court reporter commencing on here. The deposition will be videotaped. They did it. Like they're talking about exhibit B, documents to be produced. Yeah. Okay. So here they are saying defendants offered to work with plaintiff's schedule in order to conduct the deposition at a time that was convenient for plaintiff. When? When did you do that? That's a lie right there. They just noticed him. They said it will be May 30th. And by saying it will be May 30th, remember, this is the duality that's going on in Casey Eric's argument. This is a problem because all you have to do is stand there and over hammer on this to the judge and say, Judge, if he intended to work with us on the scheduling, how will he then claim that he gets to go first because he noticed Vic first? How does he claim habeas dibsies if this was just a request for a schedule? Right? That's not what Casey did. He noticed him for the deposition. If you don't respond to that, you have to make a motion to quash, which is what's going on here. I think you have 3 days. You can automatically quash it within 3 days. After that, it's a motion that has to be ruled on by a judge. So he's going to run these parallel but contradictory arguments that, look, the time doesn't matter because we're really trying to work with the schedule, but the time really matters because we go first, period. It's a problem. It's a problem up here. It's a problem up here on Casey. On Thursday, April 25th, plaintiff's email acknowledged receipt of the deposition notice and request for documents and stated, So here's the May 9th letter to plaintiff's counsel detailing the communication. So he cites his letter as opposed to just citing the email, but okay. Okay, you weirdo. I received your notices for deposition. I think that May 30 is fine with us. I need to confirm one item, though. If you don't hear from me by 8 a.m. tomorrow, assume that we're good. I would also like to depose Monica Rial at 5:31 at your office and Ron on 6/3 at your office. Are those dates good for you and your clients? Ty. All right. Friday, April 26th. Plaintiff's email stated, hey, Casey, I had to deal with a serious emergency, so I wasn't able to confirm the deposition dates. Were you able to confirm the proposed dates for your clients? All right. Defendant's response with, when 8 a.m. came and went, I directed my staff to arrange for the court reporter and videographer so they are set up for May 30th. If that now needs to change, then we need to leave May 31st and June 3rd open because your client's deposition will be first before mine. However, I'm visiting with the clients to firm up dates for you. But for me to do that, I need your client to commit to May 30th or as close as possible to May 30th. Why? Why would you have to do that to firm up dates? But we've been through this, right? We've been through this. But again, like, let me reemphasize. He's premising this on, well, we offered to work with you on the dates, but that never happened. They just filed the notice. All right. So next we have this. Yeah. Plaintiff's email stated May 30th is fine for Mr. Mignana's deposition. We can't do June 3rd and 4th, so I'll find other dates. Right? Friday, May 3rd, plaintiff inexplicably served deposition notices. What's that S doing? And document requests for defendant's depositions to occur on May 15th in plaintiff counsel's Tyler, Texas office. Scheduling the depositions in Tyler, Texas violates local rule 3.11A1. Doop-a-doop-a-doo. First of all, let's read 3.11A1. So, 3.11A. In an attempt to have uniformity and save time and expense resulting from hearings on discovery matters, that the following guidelines will generally be followed by the courts on matters pertaining to oral depositions. These are not binding rules. The Texas rules of civil procedure are binding. Local court rules are not. They're semi-authoritative. But they're saying right here, they'll generally be followed by courts. But all you have to do is give cause. But here we go. 1. A party filing a lawsuit in Tarrant County or a party properly sued in Tarrant County must give that party's deposition in Tarrant County if requested. For purposes of this rule, party indicates a party's representative when applicable. Hey, Casey, you filed in Tyler. You filed to depose Vic in Tyler, Texas. What? That would mean if Ty violated the rule by having the deposition in Tyler, Texas, so did you, right? You filed to depose Vic in Tyler, Texas first. So let me get this straight, because I'm not quite sure if you're following this, you raging super cuck idiot lawyer. You are saying that Ty broke the rules, and by saying that, you necessarily would break the same rule. You moron. What are you thinking? And let's just reread the rule, shall we? A party filing a lawsuit in Tarrant County or a party properly sued. By the way, thank you for admitting. Thank you for just going ahead and getting past the jurisdictional hurdle. You have admitted that your party has been properly sued in Tarrant County. Must give that party's deposition in Tarrant County if requested. Where did you request to have the deposition taken in Tarrant County? Where? Where's that request? Should have been in that email chain somewhere, right? Smarty lawyer, super cool lawyer. Dummy. What are you thinking? Anyway, so this is a dumb argument because it doesn't violate the rules. But if it did, they would have both violated the rules and the judge would have said, oh my God, why are we talking about this? Because let me point that out. That's in the rules too. It's right here. Right here. However, these matters are best handled by agreement of the parties. Furthermore, parties are not precluded from submitting disputes as such matters to the court for determination by proper motion and hearings. This is the, oh my God, why are we talking about this? Work it out, you morons provision. Because you go into the court and be like, he violated 3.11A1. The judge is going to go, what? Why do I care? Where did he try and depose your client in Bermuda? No. Oh, and for the record, I'm pretty sure Casey Eric's office is in Dallas County as well. So he's not even in Tarrant County. So there's not even like an implied request there. Takaki Onzai says, in preparation for tomorrow, I believe this lyric applies. You don't pull on Hirohei's cape, you don't pee into the wind, you don't pull the shoe out of Shane Holmberg's gullet, and you don't mess around with Jim Bullock. There you go. A quick recap for those who just got here. I don't know if that will work because I've got so much to do. So much to do. We're only a couple pages into the document. We're not even to the really meaty stuff yet. We're getting there. We're getting there. So this is a good one. Good big brain, Casey. Well done. All right. On Friday, May 3rd. Oh, and let me this is what the other thing I wanted to say. Right here. Notice of less than 10 calendar days under Rules 21A and 199.2A, Texas Rules of Civil Procedure, shall be presumed to be unreasonable. So, Ty, on Friday, May 3rd, notices depositions on May 15th. That is 12 calendar days later, which means they are beyond presumptively unreasonable. That means they are presumptively reasonable. So if Casey tries to come out and say, well, he didn't give us reasonable notice, he did, under the rules, give reasonable notice for the deposition. The only thing he did not give reasonable notice was for the subpoena ducis tecum, which he withdrew and said they were not valid, right? Not valid document production requests, to ignore them. Not a problem to do that, by the way. Richard G says, hey, Nick, greetings from New Zealand. Would it be possible to get your input on improving one's skills on debating, persuasive arguments written and oral, and any other helpful tips or lessons you've picked up whenever you're free? I mean, maybe. I don't know how we do that, but sure. Find a way to contact me, and like I said, I'll help you out where I can, but I don't know how to do that very well. So we could try. It'd be fun. Defendants responded with, Mr. Beard, I received the deposition notices just now for Monica Rial and Ron Toye to occur on May 15th. Did he correct his own? That's weird. Maybe I am confused. You seem to be, but you heard me say we will depose Mr. Mignana first. Can you guess what the lawyer response is? You heard me say? Yeah, piss off, idiot. And in your last email, you indicated you were going to review your calendar and advise of other possible dates after Oregon Iron Company versus Truliger 3 or Oregon 1-4. Oregon Circuit Court 1867. Why does he cite this 1867? I don't know. Now, despite these recent emails to each other, you unilaterally noticed my client's depositions for May 15th without once asking whether we were available. So, we are not. I have a deposition that day and a matter pending in Dallas District Court, and my clients are not available either. I'm also confused why you include the request for documents knowing that you did not allow 30 days to respond. Even if we could appear for deposition on the 15th, which we cannot, I would not provide documents as the requests are untimely and served in violation of the rules. I'd like to continue working with each other and will assume this is an oversight by your office. In that spirit, I kindly ask that you withdraw your notices of depositions. If not, I will file the appropriate motion with the court on Monday. All right. All right. We've been through this, so I'm gonna read through this next part here. Phil Rogie says, all right, sent. Thanks again for listening. Yeah, thanks, buddy. Thanks. Hey, Casey, the subpoena deuces tickums spelling were indeed inadvertently attached to notices. Please disregard them. Your complaint about me not contacting you ahead of time is curious since you did not contact me before noticing Mr. Mignogna. My policy is to treat opposing counsel precisely as well as they treat me. I'll be happy to enter into a mutual gentleman's agreement to confer on these issues in the future. Personally, I prefer to be reasonable with opposing counsel as that tends to improve the outcome for both sides. Regarding who goes first, I am not aware of any rule that gives you the right to depose my client first. There isn't one, Casey. That said, I'm willing to agree to let you depose Mr. Mignogna first, but only if you agree to not file a motion to dismiss under the TCPA until we have the opportunity to depose your clients. My concern should be obvious. You could depose Mr. Mignogna and immediately file the motion to dismiss, which would trigger the discovery stay. Please let me know whether this is agreeable to you. If it isn't, please provide me with the dates that are convenient to depose your client. Hi. He just lays it out there. Notice what Casey hasn't done. He's never refuted that that's his plan. He's just spurged out about everything, right? On Tuesday, May 7th, having not received a response to defendant's request to withdraw the deposition notice, defendants were forced. It wouldn't actually be forced until Wednesday, but forced to file a motion to quash and a motion for a protective order, in addition to preparing objections to the 44 document requests. Why? They were withdrawn. They were withdrawn and invalid. Still in defendant's motion, they requested plaintiff provide dates after June 3rd or June 4th for plaintiff's deposition, as indicated in plaintiff's May 2nd email above. Wednesday, May 8th. Wednesday, May 8th. Plaintiff's email stated, Casey, 5 days ago, I asked you to give me availability dates to depose your clients. You failed to do so. Please provide me with availability dates for 2 days from May 15th through May 29th. In the alternative, please advise whether you will agree to a Rule 11 agreement to A, depose Mr. Mignogna first, and B, to not file a motion to dismiss under the TCPA until we've the opportunity to depose your clients. That's not a request. So again, Casey is saying that they're asking them, Ronica, MoRon, or whatever, to waive their legal rights. But they're not asking them to waive any legal rights, right? They're trying to say that this would be a waiver of the TCPA or the depositions. None of those are true. None of those are true. This is a stupid argument. Finally, will you agree to a confidentiality agreement that in which your clients and Mr. Mignogna will agree to not publicly discuss any of the deposition testimony? I think this is in everyone's best interest since the matters discussed will be very personal for each deponent. If I don't hear from you by noon tomorrow, I will interpret your silence to mean that you will not provide the availability dates, you do not agree to the proposed Rule 11 agreement, and that you won't agree to a confidentiality agreement. In that case, we will file motions for a protective order and to quash the May 30 depositions of Mr. Mignogna. Please feel free to call me if you think we can work this out time. This is still May 8th. All right. On Friday, May 10th, defendants provide dates for their depositions to occur on June 5th, June 11th, June 12th, June 21st, and June 24th to 28th. Now notice, Ty said between May 15 and May 29th. None of these are within May 15th to May 29th. Renegade Shuriken says, Limerick, there once was a lawsuit in Texas with Vic Mignogna at its nexus. Allegations thrown, livelihoods boned, with the target securely honed. Any defense was claimed as harassing until a mighty cry was heard. How embarrassing. There you go. As of the date of this filing, plaintiff has yet to notice defendant's depositions for any of the dates provided. Later that same day, plaintiff serves a letter now claiming plaintiff is not available on May 30th. Yeah. He adds a subheading here, but he doesn't footnote it. He says it's a footnote. Is it a typo? Must be a typo. And files his motion to quash him for entry of confidentiality agreement and protective orders and letter claiming plaintiff is not available on the 30th, but fails to provide any reason why. Vic's at a convention. There you go. Here, this will be good. This will be good. Defendant is entitled to take plaintiff's deposition first. I don't know how to say this. If you can't cite to an authoritative case on point, you're not entitled to nothing. You're not entitled to nothing. And I know that's a double negative, and it means you're entitled to something. And what that is fisticuffs to the teeth. It is well settled that the party who first notices a deposition is the first to proceed. Nope. It's not well settled. If it was well settled, that sentence would be followed by a chain of citations, 4 or 5 cases deep. Not 4 or 5 cases deep. That's still shallow. 4 or 5 cases deep. You have to have, if you're saying it's well settled, just cite some law on it. Any law. And find a case that says this is well settled law. If it's well settled, that's not that hard to do. But I digress. This is a rule of practice that is followed by courts and experienced attorneys. Experienced in what? Clearly not in noticing depositions or following the actual rules of civil procedure. Defendants requested and noticed plaintiff's deposition first. We did it first. We did it first. It's not fair. Guys, I was just at a water park hotel with my children. Okay? Do you know how many times I heard this whiny garbage that Casey is spewing from my sub 10-year-old children and my 11-year-old? They did it first. They got to go extra. Why did they get things? Why don't I get something now? Why did they get 2 and I only get 1? Oh my God, Casey. Casey, this is embarrassing. You look like a baby. Shan B. Hey, Nick. Been watching your channel since the Vic drama happened, and I'll continue watching after it ends. If the haters, Keith Tidwell, don't like it, they can play in traffic. His children won't miss him. Who's Keith Tidwell? Yeah, this is the reeing. This is the reeing right here. We did it first. Defendants requested notice plaintiff's deposition first. Plaintiff also agreed to have his deposition first. No, he actually didn't agree to have his deposition first. He had tacitly, not enforceably, agreed to have it on the 30th. Period. That's it. That's all he agreed to. While there is no procedural rule that touches on this directly, an insightful order comes from the 95th District Court, Dallas County, Texas. You're in Tarrant County, Casey. But let's see. So this is Exhibit F. Hold on. Exhibit F. Here's the order. Hold on one second. Let's read through this order. Now, keep in mind, in our case, Vic is the plaintiff, MoRon is the defendant. Before the court is the plaintiff's motion to quash and for protective relief, to which defendant Wells Fargo has responded. The hearing on the motion currently... So we've already got a party switch. Plaintiff's motion to quash and for protective relief, to which defendant Wells Fargo has responded. The hearing on the motion, currently set for November 29th, is canceled for the reasons set forth below. The current dispute largely centers around who goes first in the taking of depositions. Plaintiff Hutchinson made the first formal request to depose defendant Greer. Not Russell Greer. Not Russell Greer. I wish, but it's not. Who allegedly sexually assaulted her. Defendant Wells Fargo, insisting that Hutchinson's case is a fabrication to obtain financial gain from Wells Fargo, claims that it has the right to depose Hutchinson first, and as a result, it is refusing to tender Greer, its employee, until Hutchinson's deposition is complete. Wells Fargo. So we have the opposite here. We have the plaintiff making the first formal request, and then the defendant insisting that the plaintiff going first is not allowed. All right? Pay attention. Wells Fargo argues that because it is determined that the plaintiff's case is baseless, allowing Greer's deposition to go first will provide the plaintiff an unfair advantage by giving her the opportunity to shape and mold her testimony based upon what Greer says in his deposition testimony. Plaintiff's sole purpose for wanting Greer's deposition is to hear Greer's version of the story in order to craft her own version of the facts, and Ms. Hutchinson should be required to first give sworn testimony to support all the salacious claims alleged against defendants Greer and Wells Fargo. This is not how this works. This is not how court works at all, by the way. So here's the footnote on that. The details of this dispute are well known to the parties and are not recounted here. As matters currently stand, plaintiff's counsel had most recently proposed December 10th and 13th, 2012 as dates on which to take Greer and Hutchinson's depositions respectively. In a game of leapfrog, Wells Fargo then formally noticed Hutchinson's deposition for December 10th, 2012, the proposed date for Greer's deposition, and then claimed unavailability on December 13th. Wells Fargo has also demanded that Hutchinson's deposition be taken at the office of its counsel, which, absent agreement to the contrary, is a clear breach of the custom in the Dallas area. So there you go. Undisputed language from email correspondence from Wells Fargo's counsel to Hutchinson's lawyers set forth in the plaintiff's motion. Set forth in the plaintiff's motion most accurately capsulizes the dispute. The timing of the depositions is a flashpoint. Ms. Hutchinson filed her case and must be made to answer questions concerning her allegations based upon her personal knowledge of the events upon which she based her pleading, not subsequently acquired knowledge from Mr. Greer's response. We are firm on that point. The court rejects Wells Fargo's position. Having first sought Greer's deposition, Hutchinson is entitled to take Greer's deposition first. Texas Rule of Civil Procedure specify no procedure by which a party somehow acquires a right to depose first, because that party disbelieves its opponent's claims and may, as a result, refuse to tender its witness for deposition, even though that witness's deposition has been sought first. With only rare exception, discovery must proceed on a first-come, first-served basis. It takes little imagination to see where Wells Fargo's rule would lead. Arguably, it would likewise be proper in this case for Wells Fargo to refuse to respond to disclosure requests, interrogatories, and production requests before plaintiff responded to equivalent discovery, even though plaintiff propounded her discovery request first. Granted, while there are no fixed responsive deadlines for depositions, as there are for the other discovery devices cited, such a rule as Wells Fargo urges would nevertheless lead to unacceptable gamesmanship of the very sort engaged in here. Furthermore, if there were any fixed rule as to the order of depositions, and there is not, our traditional rules of procedure would clearly give deference to the party bearing the burden of proof on the case as a whole, such that a plaintiff would have the right to call the first depositions. Hey, Casey, did your paralegal read this far? Did your paralegal read the part where the judge said there isn't a rule, but if there would, it would favor a plaintiff who bears the burden of proof? And as they have been so happy to point out on Twitter, Vic bears the burden of proof. Vic, as plaintiff, bears the burden of proof in a defamation case. He has to prove it's in the case law on defamation. Vic has to prove that the defamatory statements are not true. Once he does that, the burden shifts to the defense, and then the defense has to go ahead and prove the truth of the statements as an affirmative defense to defamation. Vic bears the burden, the initial burden. And you know it because you've been talking about it on Facebook. You've been trying to use that as a gotcha against me. It's not a gotcha against me. I'm summarizing Vic's level of burden. It's pretty low. He just has to basically assert the falsehood of the statements. But the interesting thing is, he kind of has to know what statements they're making, and deposition is a great way to figure out what those statements might be that he's not aware of, so he can assert the falsehood of them. So he bears the burden, so he gets to go first. According to the case you cited, you dummy. Why? Why would you put that case? This paragraph is the funniest devastation of your own whiny argument. And you put it there, right for the judge to see. Oh, I hope his law clerk highlights it in pink or something for him. This case is simple. The plaintiff asked first. This court will not allow gamesmanship to upend that request, and certainly the court will not pre-try the merits of the case to determine when a party is entitled to use our discovery rules. Plaintiff's motion to quash is granted. Is further ordered as follows. Defendant shall tender Greer for deposition during the month of December. In the event date of December 10 remains available, defendant Greer shall be tendered on that date. In 5 days of completion of the deposition, plaintiff's counsel shall tender the plaintiff for deposition at the offices of plaintiff's counsel or such location as shall be agreed upon among counsel for the parties. Wells Fargo's request for fees and costs associated with its response is denied. Namrek Isto says, I wouldn't be surprised if Ron and Casey went to the same school, and Casey's license to practice law was acquired from an internet school. Me and my tired, slow mind can see the idiocy here. How embarrassing and stupid. This is I'll give him some credit. I'll give him some credit. The first part of that case, where were we? The first part of that case almost makes it look like it's a case on point, right? The first part almost looks like the case is on point. But it's not. Because that paragraph flat out demolishes the idea. Here's the other problem. That's a ruling. I believe it's an unpublished ruling from a district court in Dallas County, but you're in Tarrant County. So you're going to tell a Tarrant County judge they're bound by a Dallas County order? Really? You're going to try that? It's not the best plan if this were appellate level, but it's not. This order specifically discusses the right of a defendant to take a deposition of the plaintiff first. And the court confirms that the defendant does have such right. Oh no! No! Casey, no! Oh my God! I hope you're still watching. Oh, what did you just say? You didn't even mold the argument to fit the case. You flat out misstated in the worst way. You stated it the absolute opposite. Oh, guys. It's the... Whew. No. No, no, no. Okay. Oh, I got so hung up. I got so hung up on actually reading the case that I didn't read the next line and realize that he didn't read the case at all. Oh. Can you imagine? Can you imagine right now, guys? Shane has read that case probably 10 times. And every time he's rubbed himself raw thinking about how good of a citation that was. How Casey's got him. Yeah, he's got him. Yeah. Over and over again. That's Shane, right? These are the thing of beauty. Best filing ever. And Shane is probably too mentally handicapped to see just how badly they screwed up that paragraph. That paragraph, it couldn't have gone worse for them unless the court had ordered the summary execution of their client. It's the only way it could have gone worse. Solo Beverly says, with this, you know why I asked you what I did on Discord. Thanks, Mr. Eric Cuck. Forever229 says, is this an out-of-season April Fool's joke? Oh. A request for a confidentiality protective order requires evidence. There are a lot of citations here, and I'm not going to go through each one. Blaine20 says, Casey has reached Ron's level of ineffectiveness. Did you skip my previous $20, by the way? I don't think so. You sent a $2 one for habeas dibsies. Oh, there it is. There it is. I did. Blaine20 said, I'm sorry I missed this. Blaine20 said, if only there was a third-party uninterested lawyer who could chime in and inform Casey of how much he's screwing up on this case. Oh, hi, Nick. Oh, my goodness. Oh, okay. All right. A party seeking to avoid discovery must show particular, specific, and demonstrable injury by facts sufficient to justify a protective order. Do you know what's missing from this line? Quotes. Right? Citing this, citing another case. There's no quote. There's quote here. So long as the discovery, this is from Garcia versus Peoples. So long as the discovery sought is within the scope of Rule 166B, now 192, a trial court may not grant a protective order limiting discovery unless the party seeking such protection has met this burden. The trial court isn't limiting discovery. What's Rule 192? Oh, these are Tarrant County rules. 1 second. Rule 192, permissible discovery, forms and scope of work products, protective orders and definitions. Hold on, I'm just work product exceptions. Protective order. I guess I could put this on screen so you guys can be bored reading it with me. Hold on. Here we go. All right. Here we go. A person for whom discovery is sought and any other person affected by the discovery request may move within the time period permitted for response to the discovery request for an order protecting that person from the discovery sought. A person should not move for protection when an objection to written discovery or an assertion of privilege is appropriate, but a motion does not waive the objection or assertion of privilege. If a person seeks protection regarding the time, or place of discovery, the person must state a reasonable time and place for discovery with which the person will comply. A person must comply with a request to the extent protection is not sought unless it is unreasonable under the circumstances to do so before obtaining a ruling on the motion. Well, obviously, it is unreasonable under the circumstances to do so before obtaining a ruling on a motion. Inkpenification says, Nick to Casey, bruh, look at this dude. Ho ho, my tasty of no. Oh, look at the top of his head. Again, his lips. Stolen meme. Screams of Cthulhu says, Casey, don't worry, Ronnie, I got an angle. Ron sweats profusely. Monica drools over screenshots of Drexel and Casey's filings. Magos Namaris says, are we sure Casey isn't a servitor? Also, is servitor conversion a valid remedy? I asked before mailing Ty. The local homeless shelters no longer take my calls. Yes. So, here we go. So the protective order, yeah, the case law doesn't actually say what they're saying it says, but hold on. Where are we? This doesn't really matter. Trial court may not grant a protective order limiting discovery unless they're not trying to limit discovery, right? They're trying to just eliminate this particular deposition, not Vic's entire deposition, just the time of this deposition. And that's mainly due to the acts of the other person, which are actually alleged. Here we go. The party moving, I'm skipping all of the citations, which are pointless here. Party moving for protection may not simply make conclusory allegations at the that the requested discovery was unduly burdensome or duplicative, but instead must produce some evidence supporting the request. Yeah. This is pointless here. This whole section, remember how I said earlier, this is premised on the idea that they're trying to eliminate all depositions for Vic, which they're not doing. They're not eliminating Vic's depositions. They're just changing the time because of the obvious gamesmanship by Casey. For example, in R.E. Amaya, the judgment creditor served a subpoena ducis tecum on the judgment debtor's daughter. The daughter moved for an order of protection but failed to support it with any evidence. Court held that the record contained no evidence of any particular, specific, and demonstrable injury that would be caused to the daughter by requiring compliance with the notice of deposition. They concluded that although a notice of deposition may be harassing, burdensome, and annoying, the law provides that unless the purpose of the deposition can be shown to be only for an improper purpose, or unless it is an undue burden, the trial court may not quash the notice of deposition. Conclusory allegations are not adequate. As stated in paragraph 1 of this response, defendants have a proper and legitimate reason to depose plaintiff, and such deposition is not unduly burdensome as plaintiff counsel agree to the deposition. Should we look at this case? How long is this? Oh, this isn't long at all. Let's pull this up. Let me see if I can make this a little bit bigger. All right, can we see this? Should be able to read that, I hope. Assuming your bit rate's good enough. Like I said, this stream probably gonna go a little bit long because we're gonna let's check out this case, right? So let's take a look again at what Casey says. Here's what Casey says. In R.E. Amaya, judgment creditor served a subpoena ducis tecum. Court held that the record contained no evidence of any particular, specific, and demonstrable injury. They concluded that although a notice of deposition may be harassing, burdensome, and annoying, the law provides that unless the purpose of the deposition can be shown to be only for an improper purpose, or unless it is an undue burden, the trial court may not quash the notice of deposition. Conclusory allegations are not adequate. All right, let's now see what the case says. Introduction. Southern District of Texas utilizes a uniform Chapter 13 plan in motion for valuation of collateral across its 7 divisions. Let's see. Let's go to here. This will be interesting. Okay. Yeah, let's just read it. Chapter 13 plan. So this is Chapter 13 bankruptcy. Plan in motion for valuation of collateral across its 7 divisions. In the case sub judice, a secured creditor objects to the debtor's Chapter 13 plan on 2 bases. To wit, the plan's purported failure to provide for fixed and equal payments in accordance with 11 USC 1325, and that the plan fails to provide that the creditor shall retain its lien as required by 1325. In addressing this objection, the court must determine whether pro rata payments to a secured creditor distributed after the Chapter 13 trustee fully pays administrative claims violate the equal monthly payment requirement, and 2, whether the debtor's Chapter 13 plan appropriately provides for creditors to retain their liens if a case is dismissed or converted prior to completion of the plan. This is weird. Do I have the right citation? I must have the wrong citation. 34 Southwest 3rd 354. Hold on. This has got to be the wrong. Yeah, this has got to be the wrong citation. Because this doesn't say what it's saying. Okay, so 34. Let's are you going to cover the citation to the parody site that Tug referred to earlier? Oh, we're going to cover everything in this document. We're going to cover everything in this document. Okay, so here we go. I hope Westlaw doesn't hate me for this. Okay, so here we go. Judgment creditor served subpoena ducis tecum on judgment debtor's daughter. District court granted daughter's motion for protection. Judgment creditor petition for writ of mandamus. The Court of Appeals held that judgment creditor was entitled to depose judgment debtor's daughter. Writ granted. Let's see why. Opinion. Amaya et al. Obtained judgments against Keith Wood and others in excess of $1.4 million. He has left the country. In an effort to find him, or more importantly, to find his assets from which the judgments could be satisfied, Amaya sought to depose Wood's daughter, Deborah. Amaya served on Deborah a subpoena to compel her appearance at a deposition and to produce certain documents. Prior to the deposition, Deborah moved to quash the deposition for a protective order. Trial court granted the motion for protection and severely limited the scope of discovery Amaya could obtain from Deborah. Essentially, the trial court limited the discovery to what Deborah was willing to voluntarily produce. Amaya filed a petition for writ of mandamus alleging that the trial court abused its discretion in limiting the scope and the form of discovery it sought from Deborah. We will conditionally grant the writ. Mandamus. The deposition was noticed pursuant to Rule 621A, Texas Rules of Civil Procedure. The first question we must decide is whether an order rendered to aid in the enforcement of a judgment must be appealed, or is it the proper subject of a petition for writ of mandamus? The courts that have addressed this question have determined that for anything other than what could be characterized as a final judgment, mandamus is a proper form to obtain a review of the trial court's post-judgment discovery order. So you're not appealing the final judgment, you're just appealing a portion of it. So that's, you petition the appeals court for a writ of mandamus to hear your case. All right. While it is unclear exactly what may constitute a final judgment in the context of post-judgment discovery order, it is clear that the order in this cause is the type of order that other courts have reviewed in a mandamus action. The rule under which discovery in aid of enforcement of a judgment is authorized also makes it clear that our supervision of such discovery proceedings after judgment shall be the same as that provided by law or those rules for pre-trial discovery and proceedings insofar as applicable. So post-judgment discovery is the exact same as pre-trial discovery for what the court's authority to do is. Mandamus may issue only to correct a clear abuse of discretion or violation of a duty imposed by law when there's no other adequate remedy. Because we ultimately have determined that the trial court abuses his discretion and there is no adequate remedy at law, we have authority to review the trial court's post-judgment discovery order by petition for writ of mandamus. Post-judgment discovery is specifically authorized by Rule 621A. This rule provides that all the tools of discovery authorized by the rules of civil procedure are also available in aid of enforcing a judgment. So this means that you can depose people again if you have to, or you can depose other people who may have knowledge about their money, which is a little bit different than pre-trial. You have access to more parties. Discovery and enforcement of judgment. At any time after rendition of judgment, so long as said judgment has not been suspended by a supersedious bond or by order of a proper court and has not become dormant as provided by Article 3773 VATS, the successful party may, for the purpose of obtaining information to aid in the enforcement of such judgment, initiate and maintain in the trial court, in the same suit in which said judgment was rendered, any discovery proceeding authorized by these rules for pretrial matters. The rules governing and related to such pretrial discovery proceedings shall apply in like manner to discovery proceedings after judgment. Judicial supervision of such discovery proceedings after judgment shall be the same as that provided by law or these rules for pretrial discovery and proceedings insofar as applicable. Thus, after a judgment, a party's right to discovery, the forms of discovery, the opposing person's burden to prove an exception or protection from discovery, trial court's order regarding post-judgment discovery, and our review of the trial court's order are all governed by the same rules and authorities that are applicable to pretrial discovery. Depositions with an attached subpoena ducis tugum are specifically authorized discovery tools. Further, except as specifically limited by the rules or statutes, no person can refuse to be a witness, refuse to disclose any matter, or refuse to produce any object or writing. Trial judge may exercise some discretion with the granting of a protective order and in controlling the nature and form of discovery. Masinga versus Whittington. The predecessor, construing Rule 166B, predecessor to Rule 192. However, that discretion is not without bounds. A party seeking to avoid discovery must show particular, specific, and demonstrable injury by facts sufficient to justify a protective order. Now, they said something different here. So long as a discovery sought is within the scope of Rule 166, now 192, the trial court may not grant a protective order limiting discovery unless the party seeking such protection has met its burden. Conclusory allegations are not adequate. So that's kind of where they pulled that out, but they're changing something here. Any party who seeks to exclude matters from discovery on grounds that the requested information is unduly burdensome, costly, or harassing to produce has the affirmative duty to plead and prove the work necessary to comply with discovery. Otherwise, the trial court cannot make an informed judgment on whether to limit discovery on any of these bases. Failure to follow procedure constitutes a waiver of any complaint of the trial court's action. So the hearing. Deborah's motion asserts that she's entitled to protection because requested discovery is intended for the purpose of harassment and annoyance. Her only connection to the matter is that she's the daughter of Wood. She's not an officer, director, shareholder, or owner of any of the entities identified in the subpoena or the entities who are defendants in the underlying litigation. Requiring compliance would subject her to vast, expensive, and time-consuming ordeal. Requested discovery is unduly burdensome and harassing. Improper use of discovery process, intended to harass and annoy, invasion of her privacy, and the requested discovery is irrelevant, nor is it calculated to lead to the discovery of relevant evidence. Okay? The only evidence Deborah presented to support any of these allegations was an affidavit. No witnesses were called to testify on her behalf. The full text of her affidavit, other than the formalities, is as follows. I've reviewed the subpoena that was served on me in connection with a lawsuit in which my father was apparently a defendant. I've reviewed the names of all the defendants in the 2 cases listed on the subpoena. I've never been an owner, officer, or shareholder in any of the entities listed. I do not have possession of or access to any of the books or records of any of the defendants. I do not have possession or access to any of the financial records of my father, Keith Wood. It's not a party to the lawsuit in which my father was a defendant and have no personal knowledge of the disposition of either of the lawsuits identified in the subpoena that was served on me. In response to this evidence, Amaya presented several exhibits. These exhibits included the judgments against Wood, articles of incorporation for another corporation, excerpts of a deposition of Wood. These exhibits established that Amaya had judgments against Wood and that he was when he was last deposed, he had assets worth $25 million, was living in and keeping records at a house in Waco, and that he and his daughter had previously worked together as 2 of the initial board members of an unrelated corporation. It was also undisputed that Wood had conveyed the house in Waco where the records were stored to Deborah. Trial court granted the motion for protection, quashed the deposition notice. Discovery was limited to production of records of international telephone calls since January 1st and a deposition of her written questions related to the following: her acquisition of the Waco property and her knowledge of any and all addresses of the phone numbers of her father, Keith Wood, since January 1st. Notice again what they're doing here. I know this stuff gets kind of boring. I apologize. So let's bring it back to the document and talk about this. Here we go. They concluded that although a notice of deposition may be harassing, burdensome, and annoying, law provides that unless the purpose of the deposition can be shown only to be for an improper purpose, or unless it is an undue burden, trial court may not quash the notice of deposition. That's not what it says at all. This is not the holding of the case, okay? The holding was that the trial court didn't quash a notice of deposition. The trial court limited discovery and eliminated the possibility of her being deposed. Listen to the difference in these 2 things. I will not be deposed on Tuesday, or I will not be deposed ever. Ever. I will not be deposed Tuesday. I will not be deposed ever. This is a bad case to cite. There was no evidence offered to show the time, expense, or burden for Deborah to appear for the deposition or to respond to the subpoena ducis tecum. If, as her counsel argued, she has no knowledge of her father's location or location of his or her corporate record sought, she can testify to that effect. Likewise, there was no showing that the discovery sought is solely for the purpose of harassment, annoyance, or an improper purpose. Many deponents consider any deposition harassing and burdensome and perhaps annoying, but unless the purpose of the deposition can be shown only for an improper purpose, or unless it is an undue burden, the trial court cannot limit the deposition on these bases. While it may have been shown that her only connection with these judgments or litigation was that she was Wood's daughter, it's also shown that she had previously served on the board of another corporation with Wood, leading to a reasonable conclusion that she may have learned something about him or his other business dealings outside the knowledge that the normal father and daughter relationship might reveal, nor has she demonstrated how her privacy would be invaded. Amaya is entitled to engage in discovery reasonably calculated to lead to the discovery of assets from which to satisfy the judgments. Being able to question a close family member regarding the disposition or location of records that were stored in the house previously owned by her father that was subsequently conveyed to her and where she now lives may assist in the search for assets. Probability that information relevant to the search for Wood and his assets may be discovered from Deborah was enhanced when it was shown that she and her father had together been involved in some other business activity. Anything that could assist in locating Wood or his assets is relevant. Deborah remains entitled to the same procedures for protection during the course of the deposition as any deponent, including finding a reasonable time, place, and manner to take the depositions within the rules. Deborah had the burden to plead and prove an exemption from discovery. Vic has not asked for an exemption from discovery. This is a terrible case. She failed to show that the information sought was in any way exempt from discovery or was unduly burdensome, costly, or harassing to produce. On the record before us, the trial court abused its discretion by limiting Amaya's discovery from Deborah. We conditionally grant the writ of mandamus, directing the trial court to vacate its order, quashing the notice of oral deposition with an attached subpoena ducis tecum of Deborah Wood. Okay, so I know that was a little bit wordy. But I have to... This is the problem. Right here, they're misstating the purpose of this case, and grossly so. This case is about limiting discovery, as in the person will not be questioned, the evidence will not be produced. It is not at all about changing the time of a deposition or gamesmanship in depositions or anything like that. As stated in paragraph 1 of this response, defendants have a proper and legitimate reason to depose plaintiff, and such deposition is not unduly burdensome, as plaintiff's counsel agreed to the deposition. No one's claimed it's unduly burdensome, so that's weird. Similarly, is it really similar? In Independent Insulating Glass, SW Incorporated versus State, the Fort Worth Court of Appeals held that any party who seeks to exclude matters from discovery on grounds that the requested information is unduly burdensome, costly, or harassing to produce has the affirmative duty to plead and prove the work necessary to comply with discovery. No one has asked for this. A protective order and a confidentiality agreement. Protection from the date, from the specific notice, not from all discovery. And the confidentiality agreement has nothing to do with limiting discovery. This is, ugh. Otherwise, the trial court cannot make an informed judgment on whether to limit discovery on any of these bases. Discovery is not being limited. All right, next. Oh, here's a footnote I missed. Although unclear from plaintiff's motion, a request for confidentiality under Rule 76A also requires a party to provide evidence. Therefore, whether plaintiff's request is made per Rule 192.6 or Rule 76A, plaintiff's failure to provide any evidentiary support warrants denying a confidentiality order. I don't think they failed to provide support, but I can't remember off the top of my head. So, a person seeking to avoid discovery for reasons other than privilege or immunity. This isn't happening. This entire section is superfluous. I.e., undue burden, unnecessary expense, harassment or annoyance or invasion of personal, constitutional, or property rights may also be required to produce evidence in support of the objection. Plaintiff has not provided any such evidence. Well, I don't know if that's true. Again, I don't even know that they've asked for this. Plaintiff does not provide any evidence to support a confidentiality or protective order. In connection with the motion to quash, plaintiff seeks a protective order but does not provide any evidence. Instead, plaintiff relies on generally accusing defendants of some possible nefarious reason for the deposition and concludes that the parties may be embarrassed and therefore need a protective order. As demonstrated above, plaintiff's failure to support these allegations with any evidence should cause the request to be summarily denied. I know the answer to this. Where is it? That's something different. Never mind. Hold on. Where's my... Hold on. I know I have this document. Where is this? Hold on. I wasn't prepared for this part. I apologize. I've got it somewhere here. Let's see. Here we go. Sorry about this. This is very, very professional of me, I know. Okay. I had this in a completely different place. All right. Let's pull this up. So now, where are we? Yeah. Okay, support a confidentiality protective order. Connection with the motion of plaintiff seeks a protective order but does not provide any evidence. Therefore in need of a protective order. Where's the request for a protective order here? Plaintiff's motion to quash for entry of confidentiality and protective order. Let's see. Oh yeah, here we go. So here's the all right. Sorry. I lost my spot. I lost everything. So here's the spot. Their recalcitrance is short-sighted. We'll go to right here. This is it. As their own private information may be subject to inquiry during their depositions, not wishing that any party should be embarrassed by the public unveiling of sensitive information disclosed in a deposition, plaintiff respectfully asks this court to enter a confidentiality order governing the discovery in this case and precluding disclosure of information that is confidential or private absent the court's permission. So that's the confidentiality order. And the plaintiff respectfully requests that the court quash the notice and enter a protective order that no depositions may be sought by any party until the court issues such confidentiality order. So they're not asking, again, they're not asking to limit discovery and take away the depositions. They're asking for confidentiality, and then they're trying to make sure that the court doesn't allow the parties to just keep noticing people prior to the court's ruling on the confidentiality order. That's it. This isn't a motion to limit the scope of discovery. It's a motion to limit the timing of discovery in a particular case. Okay? So there we go. Sorry, I had to get that out of, I had to get through that because I'm like, what? There is not a request for a protective order limiting depositions or getting rid of depositions, only until the court rules on this particular motion. As demonstrated above, plaintiff's failure to support these allegations with any evidence should cause the request to be summarily denied. Real quick, was there evidence? Let's see. Defendant's response to plaintiff's proposal of a confidentiality order is a thinly veiled threat of inquiring into private information during his deposition and posting that information to their Twitter accounts. Here's the statement. Here's the entry of evidence. It's right here. Whoops. Frankly, I assume Mr. Mignogna gave considerable thought to any personal privacy concerns he filed before he filed his lawsuit. Regardless, my clients have considered his request and it is declined. He flat out says right there that they intend to release the private information. That's the whole point. So the assertion that there's no evidence, I mean, there's evidence from their own counsel. From you, Mr. Eric. It's right there. Shonen X Trash says, unless it's a parody account that stole their names, Ron and Monica are in chat. Say hi, Nick. Oh, it's definitely a parody account. I'm sure they're watching, but they're not watching and commenting. Joseph Green says, is it possible that all this half-butt paperwork is an attempt to burn through the GoFundMe? Yes, it's absolutely possible and likely. I'd imagine it takes half the effort to pull this crap than it does to go through all the paperwork to say, no, this isn't relative. I think it's relevant, but it depends. It does take work to put this stuff together, and believe me, they're going to get billed for it. Their miscalculation is that Vic's GoFundMe puts him ahead of them on the overall, I guess, on the overall thrust of resources. Well, I don't know. Maybe Ron and Monica have some massive heap of cash sitting around somewhere. Okay. But so there is a support with evidence. You may not like the evidence, but it's your own words, Casey. Now, this is interesting. Plaintiff's actions outside of this lawsuit have proven that his request for confidentiality is disingenuous, and he is wasting the court's valuable time and resources. Plaintiff's attorneys have appeared on episodes of the YouTube channel for Rekieta Law. Hey! Hi! How's it going? Describing the facts of the case, the pleadings and the defendants, providing images of evidence they intend to use in the case, and discussing their legal strategy. Okay, so let's go to his citation, which is exhibit... Whoops, I forgot to look for it. Let's see, exhibit G. G. Is this exhibit G? Exhibit G. Bleeding Fool article. When was this written? Let's see. Let's read this Bleeding Fool article. I'll tell you why they picked this article, because this is a weird article to pick, by the way. Over the past weeks, there's been an increase in the attention being placed on the world of anime. Dubbed AnimeGate, this new movement... No, Weeb Wars! Come on, Bleeding Fool, don't do AnimeGate! This new movement shares several characteristics with its sister movements, Comicsgate and Gamergate. Like previous movements, this one also aims to strike back at the SJW infestation that has insidiously invaded all fandoms across the world. Prominent in this movement is the existence of a legal battleground as its starting point, one that is loosely organized by large-profile YouTubers like that Umbrella Guy, Yellow Flash, and Nick Rekieta. But the overwhelmingly characteristic of this movement, that's a weird sentence, is an incidental insight to how normies react to the initial exposure of the SJW tactics almost in real time. So then they have this video, Fear the Beard with Rekieta Law and Ty Beard. Let me check something here. Video manager. See the date of that. Let's see. Beer. Whoops. Nope. Hold on, we're almost there. I just gotta find it. I gotta find the date of this. That's the second one. The first one. Fear the Beard with Rekieta Law and Ty Beard on Vic Mignogna. So this was streamed March 5th. Papers weren't filed on March 5th. Mr. Nick Rekieta has long hosted live streams on YouTube with the aim of analyzing ongoing legal cases, offering both explanations of the ongoing litigation, possible legal strategies that could be used by the involved attorneys. These legal strategies are largely conjectured by Nick. However, time and time again, he has been proven correct in his legal opinions as those cases reach their conclusions. It was in this capacity that Nick was exposed to the ongoing drama that Vic Mignogna has been facing on his own, and Nick's legal calling prompted him to take action. After organizing Vic's GoFundMe and managing a $100,000 goal, which was reached within 15 days, Nick became even more exposed to those terrorist tactics that the SJWs employ to destroy their enemies. But Nick would not be the only normie that would learn these tactics firsthand. Vic's attorneys, Beard Harris, Bullock, and Hughes would also be exposed. 2-for-1 special on ethics complaints and Kamea-Con. Let's see. That was good. That was a good stream. That was March 21st. Okay. Watch as Ty offers some much needed support to Nick after ethics complaints are received. Those of us that have dealt with SJWs both directly and indirectly are used to seeing... I was broken up, y'all. I was very hurting. Those of us that have dealt with SJWs both directly and indirectly are used to seeing their handiwork and tactics in brazen display, but this was not the case with Mr. Ty Beard, an attorney working out of Tyler, Texas. His online presence was non-existent by his own admission prior to taking on this case. The internet can be a harsh, cruel, and unforgiving place for people like that. For a second, I feared for Mr. Beard's sanity when I learned that the autistic force of the internet, located within the Kiwi farms, was openly scouring the internet for information to provide him. My fears increased for a second. For the first time ever, I witnessed a true act of chivalry within the barren landscape of the internet. Kiwi farm users actively warned Mr. Beard of what areas to actively avoid within the site. Don't type furry in. Ty has made 3 appearances in Nick's live streams. Each of those appearances has been drastically different from one another. Viewers can see the disgust that this normie is experiencing as he exposed this form of terror that is SJWs. That's a good picture, y'all, right there. Ty appeared to be surprised at how effective the SJW tactics have proven so far. His commentary on how these parasites have been able to influence and affect people's lives over perceived crimes is a great reflection on the public's reactions to it. Ty dismissed the comparison of SJW tactics to the Salem witch trials by saying that at least those accused of witchcraft in such an arcane time received a trial in front of a judge. He also remarked at how SJWs drove such an intense amount of pressure on business owners that they would inevitably succumb to the pressure in order to receive some peace. This further echoes previous complaints made by Richard Meyer and his sabotage business relations, as well as a multitude of attacks levied against Alterna Comics. So then here's the other one, Fear the Beard, on the difference between good and bad decisions. Let's see. Oh, that was March 23rd. So there you go. Ty brought an outsider's perspective to this ongoing SJW infection and accurately identified not just a problem, but the solutions needed to successfully combat the invasion. Both Nick and Ty reached out to the fans and asked them to support a convention currently undergoing their own SJW swarm, along with other suspected criminal activities. This convention, strengthened by the overwhelming fan support, took a stand against the SJW tactics and drove the first wound on their narrative. Meanwhile, Nick's professional career has taken some small attacks from the same parasites. As attorneys Nick and Ty are both held to very high standards of behavior in their practices by distinctly different governing professional ethics boards. Nick has received 2 terrorist attacks in the form of ethics complaints from separate SJWs, risking both financial and criminal consequences. Terrorists have tried to bully Nick into silence with their ill-conceived actions. But it would be Ty's outsider wisdom that would continue to add a level of calm into the situation. He remarked at how social media has become such a powerful weapon thanks to the SJWs, and that it should be a weapon to be used against them. Crowdfunding is a game changer, Ty remarked, adding that this fan support tool would allow people like Vic to seek justice for the crimes committed against them. Due to the ever-increasing list of offenders, from busybodies to convention coordinators, Nick has changed the GoFundMe's overall goals. As Nick has said on multiple occasions, justice moves at a deliberate pace until it becomes an avalanche. With more SJWs willing to throw themselves as sacrificial lambs, the avalanche will surely be fruitful. SJWs have controlled the narrative long enough. Their lies have twisted and turned joyful pastimes into another chore. Bad people ruin good things. Fandoms are severed and destroyed left and right. Large companies are dying. Nostalgic memories are being poisoned. Childless weirdos are being trusted with providing healthy entertainment for the future generations. We've carried our share of the blame for this infestation for long enough. Vic represents our brothers, our sons, our fathers, and our friends. He needs us, and we will be there with him. For all of them like him that have witnessed as their lives are destroyed by people who are little more than oxygen wasters, the situation will hopefully lay out a blueprint that can be used for the future as more fandoms are born from the ashes of those that have succumbed to the SJW plague. If you can contribute, you will find the link to the GoFundMe below. Hey, please do. Please do. And please support Nick's channel by subscribing, as his voice and drunken rants continue to be both informative and entertaining. Just crossed the 50K subscriber count. But his passionate coverage on multiple legal cases will surely transform into more quality entertainment. You'll find the link to his channel below. So there you go. Here's why they picked it, though. Because they could have picked a lot of stuff about this. Where's the comment section? 3 responses, 1 comment. Alexander Sedge says, I've been hearing people warning me about Vic since the early 2000s. The recent allegations were thus not a surprise to me. Does that make me an oxygen waster? Or wait, am I allowed to call myself an oxygen waster like the article does, or does that violate the name calling policy? Shut up, you oxygen waster. So this is why they picked it, though, right? They can introduce a fact that's not in evidence. An unverified person, an anon on a random website, saying people warning about Vic since the early 2000s. What were they warning about, though? What specifically? Can you back it up? Have you verified their claims? Who are you? Would you say it under oath? Anyway, so there's that. There's that. Cobb says, lol, this article brought to you by Controlled Opposition. Sounds like Milo and Alex Jones had a love child with Poll in 2016. So anyway, that's the point. That's why they picked this article. But it is interesting to note that all of those times that Ty appeared on my show that are listed here were from prior to litigation. Prior to litigation. What are you complaining about? Once they entered litigation, things changed quite a bit. Where are we? Here we go. Let's see what else they have to say about me, because I like talking about me. Yeah. Discussing their legal strategy. I mean, kind of. Rekieta Law is a YouTube channel that describes on its own webpage the following. He's a lawyer who lawsplains. Sick. That is not spelled incorrectly, you liar. Legal topics to the internet, fueled by whiskey and rage. Attached images as Exhibit H. This is interesting. I don't know if this is interesting to you guys. It's interesting to me. I know some people found this interesting. Here's Exhibit H. Here's a picture of my page here. Good job. Thank you. Thank you. Pretty recent. 61,815 subscribers. Recent snapshot. Oh, we'll get to that one, I guess, in just a second. Because that's stupid. All right. Plaintiffs' attorneys are sharing information about the case of Nick Rekieta, the creator of the YouTube channel. What information about the case are they sharing with me? To be dispersed to plaintiffs' fan base and viewers of Rekieta Law. Is that the intent of what information they may have shared with me? How do you know that? How can you prove that, Casey? Can you prove that? Many of Rekieta Law's episodes have over 75,000 views from different individuals. Can you prove that? That's actually just me in my underwear clicking view over and over again. Furthermore, plaintiffs' attorneys have even attempted to sell merchandise, patches, and t-shirts in support of Ty Beard and plaintiff with the slogan, Fear the Beard, as a way to intimidate defendants and rile up the fan base of plaintiff. This is absolutely not true. This is not true at all. You stupid pile of trash. You idiot. You could have checked this, no problem. Now you've lied to the court openly. No. The plaintiff's attorneys have not tried to sell any merchandise. Patches are sold by Short Round. T-shirts are sold by me. Hey, Casey, you pull-tard. I'm not Vic's attorney, you idiot! Cobb says, lol, this art... Oh, wait, no. Mr. Obi-Wan 2020 says, remember, Nick, there are plants out there struggling to produce oxygen for these people. I think those plants are owed an apology. I think so, too. And of course, he footnotes it, and that's Exhibit I, as I suspected it would be. Just right here. Now, notice this. Image of Rekieta Law selling Fear the Beard merchandise. Yep. Yeah, my Teespring store sells it. Mine. And they don't sell that well. Oh my goodness. Hey, what's this? That's weird. Wonder who that is. They don't... Casey. I'm selling the shirts through Teespring in partnership with YouTube. We do. Ty is not part of my YouTube channel. Ty gets 0 money from my YouTube channel. Ty gets 0 money from me. Ty gets 0 money from the sale of shirts. 99.99% sure Ty gets 0 money from the sale of patches. I think part of the patches may get donated to the GoFundMe, but that wasn't at Ty's request. So how is Vic's attorneys selling merchandise? Are you stupid? I didn't think you were stupid, but are you stupid? You kind of looking stupid. All right, back up to it. Back up to the document. Here we go. Where are we? Where are we? Oh my goodness. Oh, and by the way, Fear the Beard isn't to intimidate defendants and rile up the fan base. Fear the Beard, the entire purpose of Fear the Beard is to sell the shirt. They don't actually say Fear the Beard anymore either, if you look at them, because we've got a little issue. By the way, notice what happened here? Do you guys remember a very weird chain of events related to Cuck Dynasty, right? There's a very weird chain of events where the lawyer for Duck Dynasty, for Duck Commander LLC, Rachel Blue, first sent a cease and desist letter to Ty. Is she stupid? I don't know. I don't have any reason to believe she's stupid. I think she's being weird on this. But she sent a letter to Ty first, then talked to Ty, then sent a letter to me. Why would she think Ty was selling merchandise? She specifically stated that Beard Heiress Bullock and Hughes was selling shirts and patches on their website. Why would they think that? Is Ron Toye and Monica Rial so butthurt over the Fear the Beard shirts that they contacted Duck Dynasty's IP attorney to get them to come after me, when Duck Dynasty does not defend their brand at all, anywhere? Fear the Beard, go type it into Amazon and see how many Duck Dynasty shirts you find. It just doesn't make sense that both Duck Dynasty's attorney and Casey Eric would be so stupid as to think that Ty is selling the shirts. Unless one idiot called up the other attorney and said so. Or one idiot's client, who's also an idiot, called up the other attorney and said so. How embarrassing. How embarrassing to be scared of a t-shirt. How embarrassing, you pathetic little weasel, Ron Toye. Ron, why are you scared of some cloth? Why are you scared? What are you doing? Why are you so scared? Plaintiff does not identify a reasonable time and place to be deposed. Smiley face, wink, 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 smiley. To object to the time and place designated for an oral deposition. Let's see. The party or witness must file a motion for protective order or a motion to quash the notice of deposition. Yep. Okay. let's see. So they cite Baumfalk versus Linwood. Party waived argument about inadequate notice of deposition because he did not file a motion for protective order to reschedule. Oh, okay. That's weird. The motion must identify a reasonable time and place for the deposition with which the party or witness will comply. Citing Grass versus Golden. Hold on. I've got some case notes here, but let's pull this up. So this is 742 Southwest 2nd. Here we go. This is it. The motion must identify a reasonable time and place. Let's see. That's weird. Okay, so if you... What does he say? Party waived argument about inadequate notice of... Oh, wait, yeah. Notice of deposition because he did not file a motion for protective order to be rescheduled. Well, they don't even mention a motion. The motion must identify a reasonable time and place for the deposition with which the party or witness will comply. And that's Grass versus Golden. Let's check that one real quick. So that's Southwest 3rd, 659. Here we go. Cannot type today. So here's the motion. Let's do this one. Let's see. Motion to compel a physical and mental examination. Motion to quash the deposition. Trial court granted the motion. Okay. Motion to quash. To prevail on his motion to quash, he was required to show that conducting Dr. Hauser's deposition in Houston would cause him to suffer undue burden, unnecessary expense, harassment, annoyance, or an invasion of his protected right. He was also required to show that the location he selected for the deposition was convenient for Dr. Hauser. In his motion, complained that he'd never seen him and that Vralzik's attorney had never been furnished with a report of any kind. Let's see. Based upon our review of the materials, we conclude that Vralzik's allegations are unsupported by the record. It is undisputed that no evidence was adduced at the hearing on the motion to quash and no record was made of the proceeding. Okay. So the reason I go to this, again, look at these filings. The motion must identify a reasonable time and place for the deposition with which the party or witness will comply. I checked every instance of motion in well, here we can just read. This is the motion to quash. To prevail in his motion to quash, he was required to show that conducting it in Houston would cause Vralzik to suffer undue burden, unnecessary expense, harassment, annoyance, or an invasion of his protective rights. He was also required to show the location he selected was convenient for Dr. Hauser. In his motion, he'd never seen him. Attorney had never been furnished with a report of any kind. He alleged that it is unfair and a hardship to force the attorney to drive to Houston to participate in a deposition of a person who is not a witness, having any knowledge of his physical condition, and who plans to testify that treatment and bills are not reasonable or necessary. Finally, Vralzik stated he had no objection to Hauser's deposition being conducted in either Jasper or Hemphill. Based upon our review, following the proceedings, we conclude that his allegations are unsupported by the record. There's nothing in this order that says what they just said. How do you get all of your citations wrong? How do you get all of your citations wrong? Look at this. The motion must identify a reasonable time and place for the deposition with which the party or witness will comply. citing Grass versus Golden. Subsequent mandamus proceedings subnom in RE Grass. So that's a different citation there that's unpublished. I don't know if I can pull that up. Let's see. Maybe I can pull this up. It says Westlaw. Let me see real quick. Here we go. No, wait. Not that one. This one. This one's not reported. Okay. Well, motion's not even in this one. On December 8th, this court delivered an opinion denying in part and conditionally granting in part the petition for writ of mandamus. The trial court signed an order complying with the court's opinion and corresponding order. All issues attendant to this original proceeding have been disposed of. Proceeding has now been rendered moot, therefore the writ need not issue. That's December 30th, 2004. That's right here. Why would you cite this? (3021876). That's right here. 3021876. Westlaw 3021876 is right there. This is the exact document. This doesn't talk about what you say it talks about, Casey. This is a super lawyer. Like, I can't. Guys, I have to look. I have to do my own work, right? On cases. I don't have a paralegal, don't have a secretary, it's just me. When I research these cases and when I put them in my documents, they have to be right. They have to be correct. And I can't blame somebody else. But I do it and I cite my sources and then make the arguments and I synthesize different cases. And I relate the facts of my case to the facts of the case, and I try and eliminate or overcome objections at the onset. I make a very clear argument about it. What is this idiot doing? None of these citations say what they need them to say, and none of them say what they say. That's a lot of saying. That's a lot of saying. But, I mean, my God, like, the motion must identify a reasonable time and place for the deposition with which the party or witness will comply. Texas Rules of Civil Procedure 192. Well, I can check that too. Where's that? Texas Rules of Civil Procedure. Where'd they go? Here we go. 192. What is it? 192.6a. Person for whom discovery is sought and any other person affected by the discovery request may move within the time period permitted for response to discovery. Request for an order. Oh, we read this earlier. Should not move for a protection order when an objection to written discovery. If a person seeks protection regarding the time or place of discovery, the person must state a reasonable time and place for discovery with which the person will comply. A person must comply with a written request to the extent protection is not sought unless it is unreasonable under the circumstances to do so before obtaining a ruling on the motion. Why does he have citations to Grass versus Golden? I don't understand. Let's see if they've What do we got here? Oh, I'm losing all my stuff. Yeah, well, they have actually provided that. The reasonable provision is that people can seek notice after a confidentiality order is granted, right? It's right there. Okay. Sorry. This is Like, I hear that these are bad filings, right? I was at a hotel with my kids. I wasn't paying attention to this. I hear a bad filing comes out, and it's like, well, I mean, is it a bad Then you skim it. Yes, it's a bad filing. Then you dig down. Oh my God, is this a bad filing? This is a super lawyer. This guy's rate is high. This is not a cheap individual. This is a big firm in Dallas. This guy is not going to be, this is not a guy who charges my rate. Because plaintiff does not provide a reasonable time and place for his deposition, he has waived any objection. The court should deny the motion. That's not true. Motion to compel disposition of the plaintiff. Now this is interesting. He's adding a motion in here. I'm pretty sure this motion is being added too late to go into the hearing. So that's interesting. They'd have to schedule a second hearing for this. Unless both parties agree to this one. But I think Ty could force him to hear this matter on a different time because they did this within what? When did they file this? Within like 3 days? And this is a new motion. This isn't a responsive pleading. Okay. Motion to compel deposition of plaintiff. Purpose of discovery is to seek the truth so that disputes may be decided by what facts are revealed, not by what facts are concealed. Axelson Inc. versus McElhenney. A party may seek discovery of any matter that is relevant to the subject matter and proportional to the needs of the case. Sure. I'm kind of curious about these. I don't want to go through any more. I don't want to go through more citations. These are annoying. Discovery can include evidence that may be inadmissible as long as it appears reasonably calculated to lead to the discovery of admissible evidence. Yes. When a party serves objections or claims of privilege to a discovery request or files a motion to quash or for a motion for protective order, party seeking discovery can either move for a hearing on the objections or file a motion to compel production or both. Texas Rule of Civil Procedure 193-215 and McKinney versus National Union Fire Insurance versus County of Pittsburgh and Pace versus Jordan. Court may compel a party to appear to deposition at the parties previously refused to attend. That's going to be hard to do since that was today. The request for the deposition of plaintiff Vic Mignogna was timely served, and his testimony and documentary evidence are relevant to his claims. Plaintiff does not provide any justifiable reason or evidence which would warrant unilaterally canceling the deposition. Well, I mean, except for the fact that he's in North Carolina. Defendants therefore seek an order compelling plaintiff to appear for his deposition. Request for attorney's fees and costs pursuant to Texas Rule of Civil Procedure 215.1 and Local Rule 312. Nick Thorne says, hey, I just got off work, but I wanted to apologize for my wording on that $5 donation before. I didn't mean to imply you said women can't be allowed in the military. It was a joke about how ruthless female MTIs are. Oh, no worries, buddy. No worries. Plaintiff's deliberate attempts to avoid a properly noticed deposition could rise to the level of sanctions. Let's see. What was this? Remember those local rules Casey was fond of? Look at this. Here's 3.11b. Okay? 3.11b. What would this rule say? Could this get worse for our hero? A party initiating an oral deposition shall first attempt to communicate with opposing counsel to determine whether agreement can be reached as to date, time, place, and material to be furnished at the time of deposition. Any written notice of deposition shall state as follows. Yeah, that's going to be interesting. Let's see. What did their written notice of deposition state? Do I have it here? Here's their written notice of deposition. Oh, wait a minute. What's that? What did super lawyer Casey Eric forget to do? Let's read this again. Any written notice of deposition shall state as follows. Shall is commanding language. Commanding language. This is, guys. Hello and welcome to Rekieta Talk. Tonight we'll be discussing the tragedy of the super lawyer. The tragedy of the super lawyer. The star of our program tonight is a Mr. Casey Eric, who's desperately trying to fight for his deposition notice to not be quashed. And we've just run into a big problem. In his argument, citing to the local rules of Tarrant County, Texas, and demanding attorney's fees, plaintiff states that defendant states, Mr. Casey Eric states that the plaintiffs are attempting to avoid a properly noticed deposition. But they overlooked one particular thing, and that's 311B. 311B. A party initiating an oral deposition shall first attempt to communicate with opposing counsel to determine whether agreement can be reached as to date, time, place, and material to be furnished at the time of deposition. We know that this didn't happen. How do we know that this didn't happen? Because Mr. Eric had a burden and a duty to provide that it did. Any written notice of deposition shall state as follows. A conference was held or attempted with the attorney for opposing party to agree on a date, time, place, and materials to be furnished. Agreement could not be reached or counsel will not respond, and the deposition is therefore being taken pursuant to this notice. Or agreement was reached and this notice complies with that agreement. Failure to hold such conference or to make adequate attempt to hold such conference prior to noticing a deposition shall be grounds to quash the deposition. I'm looking right here at the notice of intention to take oral deposition that was provided by Mr. Casey Eric. That was provided by Mr. Casey Eric of Kessler Collins. And shockingly absent is a certificate of conference. Let's read that local rule's last line again. Failure to hold such conference or to make adequate attempt to hold such conference prior to noticing a deposition shall be grounds to quash the deposition. That means you lose. Uh-oh, the court is obligated to quash the insufficiently noticed deposition. And since the basis of your attorney's fees claim is that you have a properly noticed deposition, let me just suggest that it certainly could not rise to the level of sanctions, and you will not be receiving attorney's fees when you can't follow the basic rules of court, Mr. Super Lawyer. If only the paid advertisement for Super Lawyer and $1 Million Litigators Club would buy you a free out of the rules of the court. But they don't. They don't do it. You freaking idiot. And you know what's funny? What's funny is that I think Ty could request attorney's fees for having to file a motion to quash an improperly noticed deposition. Oh my goodness gracious. Certainly, filing a motion that includes only unsupported conclusory allegations should give rise to sanctions. As the Texas Supreme Court stated in Masinga, conclusory allegations of the movement amounted to little more than a general objection to any form of discovery authorized by Texas Rule of Civil Procedure 202. As such, in the future, this type of motion could support the entry of sanctions rather than the granting of relief. Except this is a completely different case. A completely different case. There's other problems with it. I'm not going to go through every single thing. We'll let Beard and Harris respond to these, right? We'll let Beard and Harris respond to these. Rule 215 provides that the court may, after opportunity for hearing, require the moving party or attorney to pay the party who opposed the motion the reasonable expenses incurred in opposing the motion, including attorney's fees. Defendants timely served their notice of deposition and request for documents. I mean, they timely served it, but they didn't properly serve it according to the rules. And despite agreeing to the date and the time for plaintiff's deposition, not in writing, not signed, and not filed by the parties, plaintiff decides he does not want to be deposed, not true, but fails to provide any evidence in support of his motion to quash or request for protective order, not true. At the same time, plaintiff notices defendant's depositions to occur within inadequate notice, not true. They were over 10 days. They were 12 days notice. And attempted to jockey for position. There is no position that you're entitled to under the rules, you idiot, by choosing earlier dates for them to occur. No! Why would they do that? Next, even though defendants have provided multiple dates for their depositions, not within the plaintiff's request, plaintiff is yet to serve a notice or attempted to schedule the depositions. They don't have to. They don't have to at all. You can't compel them to schedule the depositions. Defendants request the court deny plaintiff's motion in its entirety and order plaintiff's deposition to be conducted within 5 days of the order, subject to being held in contempt if plaintiff disobeys the order. Last, defendants request that the court award reasonable expenses incurred in opposing plaintiff's motion. Prayer. Wherefore, premises considered. Defendants request that the court deny the motion filed by Victor Mignana. Deny the improper request for a protective order. Order plaintiff's deposition to occur within 5 days. Award defendants reasonable expenses for plaintiff's conduct in avoiding his deposition and for filing a motion, and request for protective orders without any discernible basis or evidence. Let's see. Here's a certificate of conference on this one. Actually, I don't believe that this is true, but I guess it probably satisfies the rules. But here's the funny thing. Look here. Here's his own Exhibit B. It's even in his own filing. You're missing the certificate of conference, you dummy. Cliff. Hey, thanks for noticing. This is actually not Max. This is Jack Archer. My buddy just gave me this. My buddy who I went to go hang out with, he got married down in Miami, and this is who I was visiting. The guy I used to watch a lot of anime with, grew up with. We both love Macross. This is the Master Collection YF1R. I just got this home. I'm bad at collectibles. I'll probably take this out and transform it and put it up on the thing, but yeah, this is very cool. Very happy. Thanks for noticing that. There we go. There we go. Yeah. What else do we got? Well, I mean, let's just finalize this and summarize this. This opposition to the motion, this response is terrible. It's a bad response. It's legally deficient. The citations are in some cases the absolute opposite of what they're arguing. Like, imagine how pissed off you are as a judge when you look up the case and it says the opposite words. Actually, you don't even have to look up the case because they provide it in their own exhibit. And you look down to it and they look up the opposite words. Or, better yet, imagine this. Imagine the judge doesn't have time to review it and he looks at your citation in court and he says, Plaintiff's counsel, Mr. Beard, what do you have to say about this? And Ty says, yeah, actually, Your Honor, it don't say that. It do say the opposite of that. So And it's in your motion, actually, if you'll just flip to Exhibit D or whatever it was. If you just flip down to that exhibit and take a look at it, you'll see that it's the exact opposite. Would you like to see my copy, Your Honor? I've got the text highlighted for you. Yoink. You can borrow that if you need to. What? The judge certainly isn't going to, like, judges are very, very busy. They probably don't have time to go through every single thing, like every citation that's in a case. They lean heavy on their law clerks to write synopses of the stuff, to kind of go through, summarize, and add executive notes to the cases. But if their law clerk misses it, and the judge says, well, what do you have to say for yourself, plaintiff? And the plaintiff's counsel says, actually, Your Honor, he was misleading you and the court, or just completely mistaken. But here's what it says. Here's the wording of the text. Now the judge looks a little bit bad, right? Because of the defendant. The defendant's counsel misciting the case. The court is supposed to, we're licensed, guys. Not only do we have to go through a stupidly expensive and annoying and somewhat grueling schooling process, right? We then have to, after going through the schooling process, we have to pass an exam that says that we're competent enough to do this. Then we also have to have ongoing education that says that we will maintain our level of competency. And in Texas, there's actually higher requirements because there's specific, I believe there's specific bars that you need to join, like the litigator's bar and trial attorney's bar and stuff like that. So there are even higher grades. This guy is a super lawyer. He's a $1 million litigators club lawyer or whatever. So he gets a free watered down cocktail at the Delta Club. I don't know. The judge is supposed to rely on our expertise. You will see this. Go spend a day in court and you'll hear a judge say, can someone tell me why you're asserting this? Can you cite the law to me, please? They don't have encyclopedic knowledge of all these cases. There are thousands and thousands and thousands of cases. Judges may hear the same one every now and then if they get the same string, but the first thing this judge hears in the day is a divorce proceeding. Then later, well, that'd be family law. Maybe not. So the first thing the judge is going to hear this day might be like a property dispute. And then later he's going to have a fist fight. And then later he's going to have some guy urinating on someone's comic book. And then they're eventually going to get to this. They hear so many different cases and citations during the day. They don't know. They don't even know the statutes. We provide that to them in these documents. If you do it wrong, then you tell the judge that it's right, and the judge looks at it and goes, oh, okay, yeah, sure. Right? They kind of take you at your word that you're not an abject moron. That's why the other side will always point out when you are an abject moron. They'll be like, no, they got this case completely wrong, Your Honor. Look at it. Let me pull it up. I'll pull it up on my computer right now. We'll just read it. Actually, here's a print off. You can read along. Of course they're going to rake you over the coals when you make mistakes like this. And the judge is going to look a little bit foolish, not knowing. And it's not the judge's fault. It will be Casey Eric's fault. Dumb. This is a dumb filing. Blaine 20 says, motion to compel defendant to seek better counsel. Blaine 20 says, Casey, this case says Vic gets deposed first. Ty, this case flat out says defendant gets deposed first. Casey, are you okay, bud? Signal if you need help. Yeah, no kidding. Casey, add 2 winky faces in your next text if you need us to rescue you from Ron Toya, because you can't be this incompetent. All right, hold on. Let me get this Funimation document up real quick. Then we'll do super chats. Then I might go play a game on Twitch or something. I don't know. I'm so tired. Very tired today. Yeah, search. Oh my goodness. I want it. I go buy it now. I should have had this up. I apologize. We're getting it done right now. Oh my goodness. Website is fast. What do we got here? We've got download. There. So this is a very short document. Let's pull this up. Very short document. No, I don't need to fill in this form. What's wrong with you? All right, so this is filed in Tarrant County on 5/29, 4 p.m. Defendant Funimation Production LLC's notice of filing of Rule 11 agreement. Remember, this is a Rule 11 agreement. They are signed. They're signed. They're served upon all parties. Comes now Defendant Funimation Productions LLC and files this Rule 11 agreement attached hereto as Exhibit A, pursuant to Rule 11 of the Texas Rules of Civil Procedure. This is a binding agreement between parties or parties counsel. Other agreements that do not follow this format are not binding, Casey Eric, in case you missed that. Let's see. Exhibit A. Theodorus Bullock and Hughes, Mr. John Volney. Cause number, blah, blah, blah. Victor Mignana, plaintiff versus Funimation Production LLC. Jamie Markey, Monica Rial, Ronald Toye, defendants, 141st District Court, Tarrant County, Texas. Dear John. And not like Taylor Swift's Dear John. This one's different. Although Ty may love this man. I don't know. Dear John, under Rule 11 of the Texas Rules of Civil Procedure, this will confirm our agreement that you are authorized and do accept service of the petition and discovery on behalf of Funimation Productions LLC. Service date is May 14th, 2019, so we're quite a ways back here. Defendant's response or answer to plaintiff's original petition shall be due on or before June 10th, 2019, and defendant's responses/answers to plaintiff's request for disclosure, request for production, and interrogatory shall be due on or before July 3rd, 2019. Please execute this agreement and email a copy back to me. I will look forward to working with you. Sincerely, Ty Beard. I agree to the terms of this Rule 11 agreement on behalf of my client, Funimation Productions. Signed, John Volney. Shocking. It's a Rule 11 agreement. How do Rule 11 agreements work? Where were we? Let's see. Control Rule 11. Oh, wait. I just have to go to 11. That might not work as well as I think it will. No! Here. Unless otherwise provided in these rules, no agreement between attorneys or parties touching any suit pending will be enforced unless it be in writing, signed, and filed with the papers as part of the record, or unless it be made in open court and entered of record. I can't express to you. Casey is wasting Vic's money. Casey is wasting Ronica's money. He's wasting their money. He didn't properly notice Vic for deposition, so the deposition should be quashed automatically. All Ty has to do is request. It's grounds for quashing. Then, the whole premise of his argument is, one, he gets to go first with a bad citation. He says, I get to go first, and his citation actually says, no, the other party does. Then his next thing is that, well, they agreed to let me go first. That agreement's not in writing, it's not signed, and it's not filed. So they didn't actually agree to you, not in a binding way that the court can enforce. So the worst thing Casey can do is go before the judge and say, Dad, Ty's being a dick. He's so mean to me. It's not fair. Because I noticed them first. And they won't let me do the deposition. I want to do the deposition. I did it first. Mr. Eric, compose yourself. My God, man, you're a member of the bar. Carry yourself with some dignity, you embarrassing sniveling heap. It doesn't matter that you noticed him first. And you actually didn't. So this is... Wait a minute. I gotta check. I have to check. I didn't want to check. Because I don't want to be wrong. But I'm gonna check anyway. Even if I'm wrong, it doesn't really matter. It might be really funny. Where are we? We're over here, right? We're over here. Let's see. Hold on. What do we got here? All this stuff. Okay, it's not in here. Gotta find it in my... Let's see. Where is... Don't I have this? I'll pull it up. Let's see. Didn't the defendants file a motion to quash? Yeah, that's that one. Don't I have this? Oh. Oh, here we go. Let's see. Aw, come on. They didn't put their certificate of conference either. Looks like they violated it too. Dang it. Hold on. So I wonder if this is a weird one. I don't know. Ties, they may have made the same mistake. But the interesting thing here is that there clearly was a discussion prior to it, but they didn't, see, failure to hold such a conference or to make adequate attempt to hold such a conference prior to noticing a death. Well, they clearly, okay. So this is interesting. Their motion lacks this paragraph, right? It does. We're going to put that out there. Naughty on BHBH. Okay? However, they clearly have attempted to hold such conference prior to noticing the deposition because they were talking about dates prior to the deposition or prior to the notices going out. We see that in the emails. I don't know if that's adequate to satisfy Rule 3.11. They might both have violated Rule 3.11. That'd suck. So I'll have to properly chastise Ty for not noticing that they didn't do that. It's probably, again, it's a local rule, so who knows if it's supposed to be on there. But according to this, it is. So there you go. I was going to laugh and say that since the initial notice of deposition by Casey was improper, then Ty would have properly noticed first, and it would be further in support of the argument that they get to go first. But I can't make that argument. I have to be fair. They can't make that argument unless their emails back and forth overcome this paragraph being gone, but they can show that the conference was there. I don't know. Let me see if... Let me pull... hold on. Yeah, it doesn't say anything on here. It's too bad. Man, I thought that'd be funny. I thought that'd be funny, but it's not. All right. Again. Smugness requires balance. But yeah, I mean, they did conference, right? Like they have their back and forth emails somewhere. I have them. Where's this? This one. Oh, no, it's here. Oh, wait, I have that pulled up. Here's the plaintiff's motion to quash. So we've got... what? No, not that. There we go. Get that timeline. See, on April 25th, they noticed, and then plaintiffs noticed defendants' depositions to occur on May 15th. That was on May 3rd. So between April and May, they've had discussions, right? Where are the emails? The emails are coming. So here's a notice. Blah, blah, blah. Here's them attempting. I mean, they clearly are attempting to get dates prior to noticing them. Yeah, May 8th. Oh, wait, no, they noticed them on May 3rd, right? That's when they noticed them. Let's see. Trying to get the timeline right in my head here. This is... It's a date on this. What's the date on this, Ty? Oh, 3rd day of May. 2017, they noticed them a long time ago. I didn't catch that typo before. You're going to have to fix that one. The Scrivener's error. But anyway, so it was on the 3rd of May. So they had, where was it? I was on the 8th of May. Well, I mean, he puts all their communications in here. May 2nd, unilaterally served we can't do June 3rd or 4th, so I'll find other dates. And then he found other dates. Noticed them. I don't know. I think it's a stretch. I think they can argue that they complied with the spirit of Rule 3.11. But I think at the end of the day, they're going to have trouble stating that they followed the rule. It does say, Any written notice of deposition shall state as follows, and it doesn't state that. And it says failure to hold such conference or to make adequate attempt to hold such conference prior to noticing a deposition shall be grounds to quash deposition. But the requirements for a conference are absurdly low, so they might be able to get by on. They might be able to get by on it, even though they don't have the paragraph. But again, I am an objective reporter. I'm not at all an objective reporter. I'm an extremely subjective reporter, but I do attempt to be as fair as possible. As fair as possible. And in this case, I think had BHBH put this in there and noted that they had attempted conference and agreement was not working out, they would have a better argument going into whenever this thing will be, that they were the first party to properly notice. They still have an argument. And that's one thing that's hard to remember about this whole process is there are actually no definitive, there are no definitive rules on all of this stuff because everything's open for negotiation, argument. You're always open to change a judge's mind. So this is a toss-up for me. They'll have to make sure they comply with that in the future. So will Mr. Eric. But, oh my goodness. Go away. There you go. That's that. But anyway, I think we covered this. Right? Didn't I? Funimation. Yeah, so Funimation's thing is done. The long and short, bad filing. Sorry, I got very sidetracked there. Bad filing. We'll have to see. I know someone told me to tell Ty that this is a bad filing. They know. Guys, they don't need my help on this. That's the funny thing. I'm not representing Vic. He's got competent counsel. His counsel is probably more competent than I am, right? They're Texas attorneys. They have vastly more experience than me. I'm just a guy having fun. I have the leisure. I have a very leisurely position in that I don't have to answer for my mistakes on this stuff, right? On a filing. Don't get me wrong. If I report something wrong, like grossly inaccurate reporting, I will have to answer for that mistake. My credibility will take a hit. But I don't have to answer for a typo or bad grammar or a miscitation. I don't have to answer for missing a little certificate of conference section on a notice of deposition. I don't have to do that. They do. They do. And so I get a very leisurely pace to read through this stuff. They're operating in real time. They have deadlines to meet. I don't. They have other cases that they're really working on as well, besides Vic's case. So, you know, we got to cut everybody a little slack. Casey lost his slack 5 bad citations ago. And that whole filing is garbage. All right, let's do these chats. Do these chats here. Okay, Mecha Space Rekieta says, Godzilla King of Monsters is a fun movie that fans will enjoy. Balanced out the monster action and live action actors. Go see it. I would love to. Shane's father-in-law says, hey man, Shane bartered some high quality Italian leather shoes for my little girl. I'll have you know. He even teared up when he gave them to me. Had to pry them out of his hands, honestly. Dog butt soy boy. Wow. Dave Youngson says, if MoRon are saving your live stream and sending it to their attorney, is that breach of copyright law? Probably not. And if so, is that a breach of ethics on the lawyer's part as they are pirating a video? I mean, maybe. Maybe. I think the real problem would be if they re-uploaded it. That would be if they're reproducing the work. But DLJ Screwjob says, I'm sure the judge will love reading this last, but I'm going first. 2 days before the hearing was to take place. Also, Monica voicing a Nazi is fine, but the Risen Bull Rangers calling Vic Fuhrer is proof of brainwashing or something. Who knows? I mean, come on. Wazoon says, Funimation sure are complying. Are they ready to throw Ronica under the bus? I hope so. I think that'd be funny. Maximum funny. Maximum funny. And I think that would be maximum funny. I think Funimation has a lot of impetus, or the impetus upon them to go ahead and throw them under the bus. They have They have a duty to their shareholders, to their parent company, to get out of this lawsuit as inexpensively as possible. And the best way to guarantee that is probably a settlement, but who knows? We'll see. But they have a long time to respond. Very generous grant of time. Hopefully that means that it's leading to productive talks. I don't know. I'm not Vic's lawyer, Casey. Shane. Tora-san, you fat idiot. Everyone on Poll. Pretty Ugly Little Liars, not Poll. I don't think Poll cares. Ben Cheever says, watching from beginning at double speed. Loving it. It's really annoying when people ask for a recap. There's never a time when that's doable. And when nobody else wants a few minute recap, just back up the stream and catch up with 2x speed, especially 15 minutes in. There you go. Guess what is going to be next to Vic's table and booth? Hopefully a big bowl of jelly beans. You just purchased a Shane's Chair t-shirt? Oh, good. I'm glad. I'm glad someone liked it. That was my base design, and my artist made it look better because I draw like a 3-year-old. But I hope you guys like that thing, the grave of Shane's Chair. Solo Beverly says, which is better, Kasoy or Mr. Ericuk? Both work. Kiwi Goes Live says, check your Twitter DMs. I sent you some Memorial Day photos you can share. No, not tonight, buddy. John Sargent says, can a judge increase a settlement if Vic wins based on how the defense presents their case? Ronica doubling down on the defamation and replies. They can't increase a settlement. They could offer, they could offer sanctions, or they could do a punitive award of some sort. Rando number 9 says, alternative stream title, Hose Mad times 24. GR People says, please tell me you plan to go over all the Jussie Smollett documents Chicago police have been releasing. I would love to. I would love to have my man Q on for that. Because, Q was very critical of Jussie Smollett. So was Drexel. I'd love to have their take on that. But I haven't seen the documents yet. I'll have to go look into it. Rithrin Sword says, Your Honor, you must disregard plaintiff's motion on the grounds that some guy on the internet unrelated to the case sells merchandise. Facepalm. Unironically, that's the argument. Kaki Onsai says, who knew that Short Round was a lawyer? Brain Trust. Alpha 13 Game says, you should go on the Drunken Peasant Show podcast. I am on June 6th. June 6th, I'll be on Drunken Peasants. Ricky de Notre Dame, thank you for the donation. Moist John says, tardy and homosexual. Formula 91 says, my wife and I heart your show. Please keep up the great work. Thank you, I will. Travis the Bard says, the life of a lawyer must be long and painful. It's usually short and painful. Jesse N says, on time and pansexual. Edmund 666777 says, late gay boomer and muted. I was muted. And then that guy says, boomer echo brother. The artsy tuber says, I wonder how many of those poor clerks wind up subscribing. All of them. And they know it. It's their dirty secret. Ari, thanks for the donation. Marty Lund says, why pay? Doesn't one of the parties like to watch? Oh, come on. Stefan Sanderson says, can't believe Vic was Godzilla while Monica, Ron, and Casey combined to play as King Ghidorah in the movie. Solid casting, even Ty as Mothra was great. Kaki Onsai says, your billing is not on time and questioning. Earju says, shout out to Jarbo the Hutt and our new Sargon Milkshake song collab dropping soon. Oh God, it's brilliant too. I bet it is. Inkpenification says, any date of King Brawley stream? Nope. I have no idea. Gotta Plague says, don't forget Mars Girl Nick. Gotta add her in case. Oh yes, Mars Girl is hideous. There we go. Rick Nikita says, Landweed changed his name to Casey and drunk drove all the way down to Texas. Finfrog says, Shane the Gobbler Cobbler. Holmberg. Perception check. Oh, we read that one already. That was at Vic's GoFundMe broke 170,000. Again, thank you all so much. Let's see how that's doing. Let's see how that's doing real quick. I'll put this up on screen while I go through these super chats. It's at 170,272. $170,272. Again, thank you all for donating. We're probably going to come up with some sort of like fund drive stream at some point. I want to make it worth y'all's time, and really do it in some cool way. There's also a guy, I need to talk to him again, but there's a guy making a couple knives that he wants to auction off. And I don't know how we're going to do it. I think we'll like try and find like the biggest donor, the biggest 3 donors or whatever in the time frame of the show. We'll get the knives. But once I've got to get the knives before I can auction them off, right? But we do have a plan for something like that. So just so you know, we're working on some other stuff there. Meshikari Russ says, "Hey Bud, question: as the 30th has come and gone, are they now going to a hearing to dispute the order of depositions?" Yes, the hearing is tomorrow. Hearing is tomorrow. Well, today technically. Even on Pacific time, we're in today. So that'll happen soon. I like the Spike Man says, "Just woke up from a stupor. Heard this is going to be a long one. Also, punch a furry." So there you go. Talbot Link says, "If Shane becomes single, he'll need to tenderize his shoes to get by with no one else to cook that leather." Lane 20 says, "Vic saves child from a burning building. Pull." That's not a good look for Vic. Shane, he didn't have that child's consent. I stand with Vic. Shane would know all about getting consent from a child. Wow. That's a little bit rough. Blue Satoshi says, "You forgot the part where Lot's daughters drugged him and had their way with him later down the line." Well, we're not going to talk about that. That was weird. The guy from that thing says, should I retract that missing persons report? On me? Yes, I'm not missing. I'm here. Dennis N says, "Lord Nick, destroyer of shoe eaters, soy toys." Kevin C, thanks for the donation. Eku Animan says, "Thank you for the donation." Eric Reeder says, "Shane Holmberg needs to admit himself to the Jenny Craig's weight loss program because his weight problem managed to destroy his home, chair, and sofa." The Bone Zone says, "I don't kick Vic, I lick tit." So there you go. Reckon says, "Love your work. Can't wait to listen to stream later. Get 'em rackets. Peace." Hey, peace back at you, buddy. Alpha 13 Game says, "You need to be on the Drunken Peasants podcast. They'll love to have you on. June 6th. June 6th. We've got it set up." John Doe says, "Shane thinks fancy ketchup is worthy of boast." Weird. Quantum Video says, "Hey Nick, I'm still looking forward to your next Ace Attorney stream. And please mention Quantum Videos. I have lots of faith and game-based content." So there you go. Check out Quantum Videos. Emmaus Catuli 2016 says, "All hail the law god for simply taking my money again. You've been hypnotized." Is this how you hypnotize? I hope so. Name says, "Would you consider reaching out to and interviewing Pastor Steven Anderson? Make for some distant Christian content, albeit slightly controversial." I don't know. Is it legal? Catalyst Kilborn says, "First time super chat." Hey, thanks, buddy. "My birthday is also tomorrow. Can you count your fingers how many times Shane blocked you?" No, I don't even know how many it's been. Lovey Side Up says, "I have some friends that help run a con in my hometown. I've suggested Vic as a guest for next year. Tiffany Vollmer, aka the old G Bulma, was there this year, so my hopes are high." Al asks, "Do you think there'll be rulings that'll be sourced in this court procedure, Mignana versus Real? If they appeal it, we'll see." Comic-Con Freak says, "Shane still thinks your intern's Twitter account is actually you. Tweeted a response saying he has no proof that you are a male and that we need to stop misgendering you. I'll try to send you the tweet." Oh, I don't care about him. Shane's an idiot. No Name says, "Real voice is a squeak toy mounted by a Great Dane." Anime Moon says, "But are we dodging Monica Real's Nookie cookies?" Ugh. Zero the Slayer says, "I spy with my little eye a Robotech Valkyrie." Yeah, there you go. That Umbrella Guy says, "Hey there, Texas." Alpha 13 Game says, "Go on the Drunken Peasants podcast." I will. Shonen X Trash says, "Do you think CK is phoning it in for a paycheck?" I don't know, man. This is a bad filing. This is a filing that could get you in trouble with the judge, and either way you'll look foolish. Mr. Leon says, "So Nick, I'm confused. Is there no defense against a filing for a TCPA? If they file it, there's nothing Ty can do." Well, no, they get a hearing. They get a hearing on it, but it's just discovery is stayed until after that hearing, and that hearing could be up to 90 days away. So if they depose Vic and today, for example, and then file the TCPA, it could be up to 90 days before Ty can depose Ron and Monica. And that's a waste of time. And they've already expressed their intent to release the deposition to the internet. So they're going to ask Vic embarrassing questions that they know the answers to. You guys probably know the answers to them as well. If you're fans of Vic, you know there's some embarrassing stuff, I'm sure. Stuff that he would say that, you know, that doesn't represent the best of him or whatever. You guys know about this stuff, I'm guessing. And so it's not illegal, though. It's not illegal. It's not terms for being terminated or anything like that. But they just want to drag his name through the mud because they don't like him, because they're bad people. Okay. BB says, Nick, check out Viva Frey on YouTube. He's a Canadian lawyer. I think you should reach out to him about doing a stream. He seems like a good dude. Super Range 128 says, reading a visual novel, and there's a quote, if all we had were emotions, we would hardly be giving any real evidence. I thought of Ronica and laughed. Ryan Gordon says, does Ron think if he gives his lawyer all his money, Vic won't get any, therefore win? I guess. Bad plan. Ryu Sketches says, is it possible that Casey is secretly I stand with Vic and is making his work easy to deal with on purpose so that Vic can't win? No, he would not risk disbarment for such a stupid plot. Talbot Link says, Casey, we can't do depo before this day because I have obligations. Also, Casey, he's using made-up excuses not to come to our depo. Quarius Walker says, representing North Carolina, whoop whoop. Raise up, rip your shirt off, spin it round your head like a helicopter. Mr. DJ Fly Eye says, Shane on Twitter is making his laps, saying that Casey is schooling Ty. I think Casey is trying to virtue, projection, and optics to win. Hence, that's why Shane's stands are all appalled with outrage. Be appalled that someone thinks that Shane is either smart or worthy of listening to. That's the most outrageous claim I've heard today. And it would be that fat dummy Torah, right? Like that's who it would be. Asphyxiation says, Books Garment Sporkery wants to know if you ever call your boy Ty and open up the call with, is this as stupid as I think it is? Keck is Swedish. No comment. John West, thanks for the donation. Sean Burgess, it sounds like Ronica's been feeding Casey so much that he now knows quantum physics. He's so woke, he's clearly messing up on purpose. Alex Blackfoot says, so many ands in a single sentence. I may be a brainlet, but is it supposed to be that way? Most likely, no. Otmendo, T-Man, thanks for the donations. Fluffy Side Up says, hey, Nick, if I want to go ahead and start learning the general basics of law, what books or websites would you recommend for that purpose? This channel. This channel here. Other than that, I mean, if you like, it depends on how much you want to learn, but go to a law school, whatever tier, it doesn't really matter. Look up the reading list for a specific class. Find the textbook, like for example, Constitutional Law by Erwin Chemerinsky. Okay, that's a pretty good con law textbook. Go to Amazon and buy an outdated con law textbook. Just do that if you want to learn the basics of it. And you can probably get them pretty cheap, especially if they're an old edition. Get it used and then read through it. They're like that thick, so have fun. Other than that, there are popular level books on the law. I don't really know them because I had to read all the grad school level books. So, Lord Blackwinds, you could read Scalia's books. Scalia has a couple books on legal writing and legal reasoning. Those would be helpful. Lord Blackwind says, I expect the last page to be just one long. Momiji says, what beer do you prefer? I'm a stout man myself. None of them. I don't prefer a beer. The best one I've had was an Allagash, which was aged in bourbon barrels. Something. I have a bottle of it. I have the empty bottle somewhere. I don't know where. Allagash. Blaine20 says, habeas dibsies. Mr. DJ Fly says, Casey, Russian. This is your last warning. Vic, Colonel Topman's voice. I don't know what the. Why do you say? What do you say, John? Ty, John Rambo voice. F him. Let's see. DCV Titan says, how embarrassing. Hashtag super lawyers. TLJ Screwjob says, if Landwy is still worse, I need to watch it soon. Oh, buddy, you gotta watch the Maddox stuff. Go watch the Maddox stuff. You won't be disappointed. That lawsuit is so stupid. M says, Super Weenie Hut Lawyers Jr. Texan83 says, you know what would be funny? If the morons in the chat were the real deal, but no one believes them because they aren't acting dumb enough. DCV Titan says, the great Casey strikes out again. Harbinger 345 says, how do you destroy yourself in your own motion? Ask Casey Eric. Chris Nemo says, Casey is the hero Vic needs but doesn't deserve. True Primarch of Chaos Undivided says, so this is the power of a super lawyer. Isn't it? It's unimpressive, isn't it? Zypher Warrior says, Casey at bat, worst pinch hitter ever. The Fat Man 56 says, so this case is like Mr. Beard won the lottery. Not the lottery. Actually, you know what? It'd be much better to work with a more competent attorney than this. This is a waste of time and it's going to cost everybody a bunch of money. Shan B, thanks for donation. DCV Titan says, are we sure Casey's paralegal isn't Canadian? I have no information on that. Michael Gonzalez says, Casey is F. How did Casey get a law degree? Looks like he does not know what he's doing. Lol. I like the Spike Man says, Hail whiwit her. Oh, whoa, no, Oni, please don't whit me. Whit me. I don't know how that goes. Shonen X Trash says, everyone hitting up the idiots up on Twitter. Can we go for more mocking and less anger? Mocking is more effective. Make it funny. Dunk on them. Yeah, that's true. Texan83 says, can we really call them MoRon? As accurate as it may seem, we all know Monica never comes first. Probably not even second or third. Fifth, maybe. Fifth, Bulma. Sardonian says, hey, see my message in your Discord, please. Okay. What do we got here? In my Discord? I don't know. I don't know. I don't know where it is in my Discord. I don't know if I'll have time to find it. I don't know how to find this, buddy. I hate Discord for this reason. Oh, wait. The fear must be setting. Oh, please call Shane out on this. This is SGS Sammy's videos, not yours. You're posting for Nick's. Haha, Nick is super triggered. The fear must be setting in. What am I afraid of? That's not my video. Okay. I guess Shane saw SG Sammy's video and thought it was mine or something. What would I be afraid of? Do you think these people are going to sue me, Shane? For what? For what? All right. Anyway. Zachary Zwickle says, oh no, don't let Shane know that you cited the wrong citation. Might become his next gotcha moment and use it as proof that you're unqualified lawyer. Hammer Bro, thanks. Matt Ranastate, thanks. Snarkticon DM says, not finding a paper? Hire Tug for your filing. Yeah, no kidding. Bad Dragonite says, Nick searching for documents. Whoa, Kimosabe. Yeah, sorry. Sorry, I hated the dead air, but I had to find it. Guru says, lol, Shane claiming Vic no-showed a deposition. Yeah, just so you know, I'm pretty sure that Vic was not at Ty's office today. Pretty sure Casey Eric, Monica Rial, and Ron Toye were not at Ty's office either. So, Asphyxiation says, are we sure he hasn't hired Russell as a paralegal? Nope. Brian Souza 16 says, this stream is awesome and I'm glad it's my birthday. Hey, happy birthday. Thanks for the birthday gift, Nick. Have some money. Thank you. MMA4 says, payday today, have some of my Monopoly money. Thank you, sir. Poor ma'am. Snarkticon DM says, dogs and cats living together, mass hysteria. Snarkticon DM says, change the show name to Whiskey and Rage. That's a good change. That's a good change. I'm not the biggest fan of lawsplaining the interwebs. I made it up as a joke before I thought I would ever have a channel with people watching. Tower Link says, I doubt whiskey is the answer, but it's worth a shot. DZV Titan says, Casey been spending too much time with Shane. Don't spend time with Shane. Nick Sack says, Nick, does Ty get money from your YouTube station, though? Nope. Not even my YouTube station gives him money. Oh, I missed a couple of these. Don Williams and Barrow SX. Don Williams says, if we could get the GoFundMe up to 200K, it would be great. Mars Girth needs an invitation to the party. I agree. If we could do that, that'd be awesome. Barrow SX says, hey, Nick, love your streams. The story really infuriates me because I had to drop out of college because of false sexual assault claims against me that almost ruined my life. I hope these scumbags get what they deserve. Me too, bud. Me too. Actually, I mean, that didn't happen to me. I just hope they get what they deserve. Chaotic Vic says, I make memes of MoRon. Can I be Vic's lawyer too? Everybody's Vic's lawyer now. Snarkticon DM says, Nick shirt, fear the chin strap. Finn Frog says, Poltardgeist, spooky fools. Forever229 says, whisper to me, daddy. IT Weeb says, whisper more, Nick. I'm almost there. Kov, thanks for donation. Same with Guardian Spader. Short Round says, hashtag fear the beard patches back for a limited time. So go check out Short Round's Etsy store. You can find the Fear the Beard patches there if you need one. If you're too pleb to have your own, here, check this out. Check this out. You got to have your Fear the Beard patch and your Don't Fear the Beard patch, right? Yeah. Got to have that too. We don't fear the beard. Hashtag kick Vic. Thanks, Ron Toye, for buying that for me. That was nice of you. Let's see. Let's see. Can we see your office setup? Show us, senpai. I mean, kind of. Kind of. Do you want to see my, like, my computer, I guess? Oh my goodness. This is kind of difficult. I don't have a lot of cable to work with here. So here we go. We got a big screen here. Screen. Books, microphone. More books. More books. Vault door. About it. I don't know. I don't know what you want to see other than that. I gotta do a walkthrough at some time, but I probably have to clean up the place. Okay. Makini90 says, so that whole side is doing everything in their power to lie, cheat, sabotage, and destroy Vic in every way, shape, and possible. But because the Stand With Vic crowd refuses to let Vic's name get destroyed, they're the bad guys. That's how it always goes. That's how it always goes, right? That's the way these people work. Let's see. Temet Nosko says, glad I caught tonight's stream. It's a good one. Bad Dragonite says, the intimidating t-shirt argument was literally a Twitter lawyer argument months ago. Now we know where Casey is getting his embarrassing arguments. Thomas Madden, thanks for the donation. Talbot Link says, ask Casey about his chair. The public wants to know. Philip Beverly says, super lawyer meet ultimate lawyer. Yes, I'm now the ultimate lawyer thanks to Anime Matsuri. DCV Titan says, super lawyer, you keep using that word. I don't believe it means what you think it means. I think it means the exact opposite, in fact. Racuna says, here's cash from Arkansas while we're above water. Good luck. Good luck. Stay above water. Bad Dragonite says, hashtag fear the beard was just telling them to get a lawyer. It was. It was, actually. It's something I've been saying the entire time. Get a lawyer. Shut up. Get a lawyer. John Sargent says, I believe Casey is a truck lawyer. Could be. Raider J says, Landau 2, Tortious Weeaboo. God of Plague says, wouldn't that one comment in the article be hearsay? Probably a lot of comments in the article are hearsay. I don't know. Finfrog says, sounds like someone will have steamy butternut quash for dinner. I see. Narcoticon DM says, all your K-Star belong to us. DCV Titan. Where'd it go? Says, he can't be this incompetent, yet we seem to be getting a mountain of evidence to the contrary. I know. That's been the worst part about starting this channel, is reading other people's documents and realizing how bad many of them are. Dustin Fritz Farr says, quote, Ty Beard, chicken poop law. This is a family-friendly stream. Brian Goza says, do you think if you handled this case and had to work against Vic and Beard, you could possibly win? Also, could Casey's incompetence be a ploy? I don't know if you could win or not. I think the win for them is probably in settlement. Could Casey's incompetence be a ploy? Likely, but not. No. Possibly, but not likely. How's that? Crow751 says, kind of glad you aren't the crying drunk type. Yeah, that'd be terrible. Shane Gosman. Sorry, I missed this one earlier. I met a man at a bus stop who was caught selling cocaine in 2013 and not charged until 2018. Georgia's statute of limitations is 4 years for that crime. How can you charge after the statute of limitations are already passed? Prosecutors do what they want. You have to challenge it. Snarkticon says, Casey Eric, arse attorney. Texan83 says, could any New Zealanders in chat please contact me on Twitter? Same as username here, discussing a possible Fear the Beard patch order. Al says, say in Tug's accent, I love that umbrella guy. For his opening. There you go. I love that umbrella guy. Super Captain Chris says, as much as I didn't want to, I remembered Mars Girl exists. I've been bedridden with PTSD ever since. What's going on with her? No idea. No idea. She's apparently suing a bunch of people, but those papers just aren't showing up. So who knows? Takes time to draft them. Rolana1 says, could Casey be sanctioned for filing this stupid, as it clearly wastes a judge's time? He could, actually. Yes. Lane 20 says, Casey is employing the Keystone defense. Circus music plays. Timothy Reaper says, even the best and brightest of us has the occasional bout of cerebral flatulence. They do. They do. Nick's adult like Beard says, hey, look, you're an adult now. Now in Vegeta's voice, Casey, his power level is over 9,000. Wait, not. It's over 9. Barely. How embarrassing. Trent Michael says, Ronica, bit of advice. Let me quote Liar Liar. Settle, 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 settle. Bizman Resident says, have you watched the Thin Blue Line documentary? No. Blaine 20 says, has anyone seen Shane and Casey in the same place at the same time? Just wondering. Talbot Links says, family friendly show. Is that why you don't sing? To keep the kids from crying? Yes. Devil Hunter Nero says, any news on Meyer versus Wade? No. No. I'll have to check and see if there's anything going on there. To my knowledge, nothing new has happened. So that's it, guys. That's the show for tonight. Let me get that outro going. We get that outro going. We'll answer some we on here. Here we go. Nope. Yeah, there it is. There's the outro we're looking for. Lane 20 says, how long till someone could report Mars Girl for fraud? I don't know. Fraud's really hard to prove, especially on GoFundMe. No Twitch. I might do Twitch. I might. Will I sing with Vic? I don't know about that. I am not like a public singer type guy, right? Like that's not what I like to do. So we'll see. We'll see. Plus, I don't know any of the songs that Vic sings. They're all like anime songs. All right, guys. Thanks for hanging out with me tonight. I may stream on Twitch. I got to get some food in my belly. I'll let you know if I'm going to do Twitch. I'll announce it on Twitter. Time is it 2:25? I'll do Twitch. Okay, I'll do Twitch. I'll do Twitch for a little while. I'm not sure what I'm going to play yet. But head over to my Twitch channel if you want to hang out a little longer. Those chats are usually a little more chill. Thanks for watching tonight. We've got big stuff coming up. I've got Hellendale, a UK attorney, who's going to come on and help me talk through Article 13. A lot of people have been requesting that. We've got some other stuff, and I can't really remember it right now, but it's going to be good. Tomorrow, of course, I will try and bring you the information from the hearing, no matter what happens. So, all right, guys. Have a good night. Peace. Peace.
Spice to the mix, but the reason we're here and the one that we cheer is the one who is showcasing us his career. So pour out a glass for the tea. Post on Twitter as we hear lawsplaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the law what we